Okay, we can start whenever you want, I think.
All right. Good morning, everybody. Right. I'm gonna use that gavel. No, I'm not gonna use the gavel. Yeah, pound the pillow. Well, good morning, everybody. Just want to make sure that our technical people have had the opportunity to make sure that everything is turned on. Let me invite everyone to the Little Hoover Commission hearing on the California Environmental Quality Act, Part 1, Thursday, March 16th of 2023. My name is Pedro Nava, and I'm the chair of the Little Hoover Commission. Thank you all for joining us today, whether you're here with us at the Cal EPA headquarters building or you're tuning in online. Let me introduce the other commissioners who are here. Joining us today is Vice Chair Sean Varner and Commissioners Dion Aruna, David Biber, Cynthia Buisa, Anthony Cannella, Bill Emerson, Gil Garcetti, and Jana Sidley. We also have legislative members of our commission who sometimes participate in public meetings, other times by Zoom. Those would be Assembly members Philip Chen, Liz Ortega, and Senator David Min. I would be neglectful if I didn't mention that for Commissioner Buisa, this is apparently her last meeting. I regret that you are leaving. I understand that there are some other opportunities available to you, but I do think it's important to acknowledge your perspective and the contributions that you have made during your time on the commission. We have all benefited from your experience, from your advocacy on behalf of people who have no voice, done in an articulate and compassionate manner. And I think it's important to also mention that you're a published poet. And I would suggest to those that want to read her poetry to look it up where books are sold. So thank you, Commissioner Buisa. We also have commission staff. Of course, without them, our work would be relatively meaningless and anonymous. Executive Director Ethan Rarick, Deputy Executive Director Tamar Foster, Analyst Ashley Hurley, Allie Powell, welcome, and Shara McAllister, welcome to you too. Project Managers Crystal Beckham and Tristan Stein. We have some housekeeping to do before we turn to our subject. We're going to break at noon and we'll reconvene the meeting hearing at approximately 1 p.m. The commission will hold its business meeting during lunch in this room. The business meeting is open to the public, and if you wish to, you are welcome to attend. We're live streaming today's hearing on Zoom, and we're being joined by members of the public who are attending remotely. We will have a public comment session at the end of the hearing. If you're here with us in person and you want to make a public comment, please fill out the public comment slip and give it to one of our staff members. Members of the public who have joined us online will be muted during the hearing. Those of you who wish to make a comment will be unmuted during that public comment session at the end of our hearing. If you'd like to make a public comment online, please use the raise hand feature in Zoom by clicking on the hand icon to join our public comment queue. If you've joined us by phone, you may send an email to littlehoover@lhc.ca.gov, letting us know that you want to address the commission. Please provide your phone number from which you have joined the meeting so we know who to unmute. Staff will be monitoring raised hands and emails requesting comment throughout the duration of the hearing. As is usual at commission hearings, public comment is limited to 3 minutes per speaker. We are recording today's hearing, and after the hearing, staff will place a permanent link to the recording on our website and upload it to our YouTube channel. Now let's talk about today's hearing. This is the first in a series of commission hearings examining the California Environmental Quality Act, better known as CEQA. Since its creation in 1970, CEQA has been California's premier piece of environmental legislation. CEQA requires that public agencies and decision makers evaluate the potential environmental impacts of a project, determine if those impacts will be significant, disclose the existence of significant environmental impacts to the public, and mitigate those impacts to the degree feasible. CEQA has also, however, long been at the center of debate and controversy. There is intense disagreement both over CEQA's effectiveness and over the scale of the law's impact on housing, land use, infrastructure, and economic development. Some critics of CEQA argue that the law impedes the realization of state policy priorities around housing construction, infill development, and even addressing climate change. Defenders of the law, meanwhile, point to CEQA as a vital tool for achieving state environmental goals, advancing environmental justice, and providing public awareness over development decisions. This hearing is part of a commission study designed to explore the debate that surrounds CEQA and evaluate CEQA's effects. Today's hearing will provide general framing with respect to the debate over CEQA. As I mentioned before, today's hearing will include a morning and an afternoon session. The morning session will feature a series of panels during which commissioners will hear different perspectives on some of the key questions in the CEQA debate. During the afternoon session, panels will present contrasting evidence regarding CEQA's impact on housing and other issues. I'd like to thank Commissioners Sidley and Aruna for serving on the subcommittee for this study and for their leadership on this crucial topic. I want to warn witnesses who are here with us today, and don't look alarmed, but you can expect to be interrupted. What I have come to learn about the commissioners is that they are diligent in reviewing material. They will have reviewed any written statements that you have submitted in advance of the hearing, and most likely have already framed some questions based on the material that they have already seen and reviewed. So if you find me interrupting you during your presentation, please just take a deep breath and try to answer the questions that will be presented by the commissioners. And with that warning, I'd like to ask Executive Director Ethan Rarick to please introduce the first witness.
Thank you very much, Mr. Chairman. So the first session this morning features two witnesses, Chris Elmendorf and Sean Hecht. They will, Professor Elmendorf will speak first, and then Mr. Hecht, and then they can take questions jointly, or as you mentioned, perhaps individually beforehand. Chris Elmendorf is Martin Luther King Jr. Professor of Law at UC Davis Law School. He works on property and land use law, election law, statutory interpretation, and administrative law, and is a leading authority on California's planning framework and housing law. His research has been published in numerous journals, too many to mention here. He holds a bachelor's degree in economics and environmental studies from Oberlin and a JD from Yale Law School. He will be followed by Sean Hecht, who is managing attorney for the California Regional Office for Earthjustice. Previously, Mr. Hecht was co-executive director of the Emmett Institute on Climate Change and the Environment and Evan Frankel Professor of Policy and Practice at the UCLA School of Law. His research interests include examining the relationship between environmental justice and mainstream environmental advocacy, as well as analyzing the role of environmental impact analysis under CEQA and other laws. He previously was a litigator and worked later for the California Department of Justice. He holds a bachelor's degree from Yale and a JD from the University of Michigan School of Law. Professor Elmendorf. And commissioners, as you can see, the slides are visible in front of you on these screens and behind you as well. Yeah.
Next slide, please.
I might mention to the commissioners that Ashley agreed to work today and run the meeting from afar, even though she has COVID. So she's doing this. So thank you, Ashley. Go ahead, Professor Elmendorf.
Okay, thank you. Next slide, please. So what are those environmental problems that I have in mind? Primarily climate change and all the things that come with climate change. So dealing with wildfire risk, which will require managed burns on a far larger scale than we have managed in the past in California. Dealing with rising seas, which will require adjustments to patterns of living along the coast. Electrifying our entire energy system, replacing fossil fuels with electricity, which is going to require new transmission, solar farms, many other things like that. And maybe above all, facilitating urbanization so that more people can live in close proximity to one another, and the exorbitant cost of housing can come down to a more reasonable level. All of these undertakings requires us to be able to build things and to build things fast. And CEQA is not set up for getting things done fast. Next slide, please. So I can describe this assumption as outdated, and I think Sean might even agree with me with respect to at least this type or this class of projects that I have in mind. But even if the assumption is outdated, that still kind of leaves the question of whether CEQA is a big problem or a little problem in the scheme of things. And my take on this is a little bit contrarian. I am very skeptical of the data that is mounted on both sides of the argument, both the data from the CEQA apologists and the data from the CEQA skeptics. And I think the best hope for figuring out whether CEQA is a big problem or a little problem is not to look at data, but to talk to people who are in the trenches, to do more of a qualitative analysis of people's experience with the law, qualitative analysis of the law itself, and particularly to focus on the loopholes in the relationship between CEQA and state housing law, which I will talk about in a moment. Next slide, please. So in the domain of data hype, please advance. I would point first to the arguments of CEQA defenders who tend to make arguments of the form. Yes, please.
So I have a question, but first an observation. I was having dinner with a friend last night and I was describing the hearing. He's a doctor. And he said that reminded him of a medical school learning that is feelings are facts, which is sort of your point about CEQA. That is, people's perception of what's going on is as influential as the fact whether there is or isn't litigation and all the things that were studied that you cite in your testimony. So I'm agreeing with you.
Yeah, I'm not sure that I would say feelings are facts in this case. I would say
perceptions are facts.
I would say credible threats are facts.
Okay, my question relates to a 2014 Little Hoover Commission report. Some of us were around in 2014, and we studied climate change mitigation. Mm-hmm. And there are 5 major airports in the state that'll be underwater, if I remember correctly, in 2050. And so mitigating that is a big deal. And so could you help me understand how to think about the infrastructure changes just with respect to climate change and airports, and what the likely CEQA process would look like for those 5 airports?
I'm going to defer to Sean on that. Have you ever reviewed an airport EIR? Or there's going to be some form of probably seawall construction or relocation of the site of the airport, but
yeah, I don't want to talk out of turn here, but
I would just tell you, you don't need to worry about that.
Okay, well, I appreciate that. So the CEQA process certainly in a situation like that would involve having an examination of what the impacts are and how to mitigate them. That has been challenged a little bit by some court decisions that have suggested that we're not supposed to look at the impact of the environment on a project. The inundation of an airport by the sea is not necessarily considered an impact, but instead by the impact of the project on the environment. But it's also true that to the extent that that some sort of new construction gives an opportunity for an agency to examine the ways in which that airport intersects with sea level rise, CEQA facilitates that and enables local governments to develop potential mitigation for that because, for a bunch of different reasons. Ideally, that would just be worked into the project as part of the project mitigation, and the agencies ideally would have an incentive to do that. In practice, I can't tell you how it will work out in any particular situation, but ideally, and in some actual cases, CEQA has actually really acted to facilitate development of sea level rise mitigation.
Thank you.
So anyway, as I was saying, the standard argument of people who don't worry too much about CEQA is to say, well, only a small share of housing projects, say, or only a small share of some other type of project requires a full environmental impact report, or only a small share of housing projects face CEQA litigation. But those statistics don't tell us anything about what was undertaken to avoid preparing a full environmental impact report for other projects, who was paid off, what kinds of reductions in the scale of the project, what kinds of agreements were entered into upfront, nor do they tell us what kinds of negotiations took place to avoid litigation, nor most of all do they tell us what kinds of projects were never proposed in the first place because of worries about CEQA risk. So that 3% of projects face CEQA litigation or small percentage require EIRs could be consistent. In fact, isn't on its face consistent with a world in which CEQA is not much of a problem, but it's equally consistent with a world in which CEQA is a huge problem. And so we just can't use that kind of statistic to adjudicate between these two possibilities.
So
Thank you.
Professor, if I may just.
Yeah, let me just, for my commissioners.
Yeah.
I'm unable to see when you want, normally we do this on a big screen or a round table, but feel free, all right? Because if I miss you, I don't want you to be frustrated because you didn't get to ask your question. So please go ahead.
So Professor, along the lines of how you're testifying, if you could share for the commission, just at the very high level, you know, what triggers CEQA? And so you have this CEQA discussion with just about every discretionary decision happening in the state of California. So like just about everything we do now, because there is talk about this is the law that swallowed the whole. So I think it's important for the commission to understand what triggers it, what doesn't, particularly in San Francisco, there are no ministerial decisions. So, you know, candidly, I'm a practitioner of CEQA, so I have a little bit more insight here, but I think that's important for the board to understand when you're talking about these numbers, like, what is the universe?
Yes, I apologize for not starting at a more basic level. So you might think colloquially that a project is something like an airport or a dam or a highway, but a project for CEQA purposes is any decision of a government, whether it's for its own undertaking or to approve a decision of a private permit applicant, any decision that involves any element of discretion that would allow the government agency to respond to concerns about potential effects on the lived environment locally or regionally. So it's the trigger is always discretion, and discretion that can be exercised in some way to respond to things that could be characterized as an environmental concern. But what counts as an environmental concern as well is not just things like endangered species, it's also public health, it's also local sensibilities about what is a special resource, what is of locally historical significance, or what is too noisy or uncomfortable for people.
And it is also policy decisions, you know, very much policy. So it's not a physical project necessarily. It's also policy decisions, which may also trigger a CEQA analysis. So
yeah, so if you're updating a city's general plan or zoning, that also triggers CEQA review, even though it does not itself directly change the physical environment. It sort of lays the groundwork for a change. Okay, so anyway, so I want you to be very skeptical of studies that point to only a small share of projects requiring an EIR, only a small share of projects facing litigation, because I just don't think those studies answer the question that you should be trying to answer, which is CEQA a big problem or a little problem? I also think you should be skeptical of studies on the other side that point to plaintiff win rates. Some CEQA critics will say, well, look, if you look at the universe of cases that generate a published opinion, plaintiffs win half these cases. That must mean that CEQA is a huge problem, because you go into court, you've got no idea as a defender of a project whether you're going to win or lose. It's like a coin toss. And again, I think the problem with that argument is you're looking at this tiny, tiny fraction of the universe of potential CEQA cases, right? What are the cases that result in a published opinion? It's in all likelihood, one, it's the cases that reach the Court of Appeal, but two, it's the cases where the Court of Appeal thinks it's making new law or is doing something significant. And those are likely to be the hardest cases of all. So it's not too surprising to me that plaintiffs end up winning about half of those cases. And in fact, there's a result that has been the subject of a lot of work by economists as well as law professors for the last 40 years that suggests that under a wide variety of different legal standards, you can end up with an observed plaintiff win rate of about 50%, which again is just the consequence of the hard cases being the ones that result in an actual judicial decision. All the other decisions, all the other potential cases get settled. But it's the settlement, the stuff we can't see, where the CEQA problem is either a big problem or a little problem. But that's what we would need to see to really understand the scope of the problem. So if you were to take a social science approach to trying to answer the question of how big a problem is CEQA, what you would do is not look at EIR rates or litigation rates or win rates. What you would do is say, what is the development pattern that we have observed with CEQA in place? And how can we estimate the counterfactual development pattern that would have been realized, or most likely would have been realized, without CEQA? And the problem is, we just don't have any good way to estimate that counterfactual. There's no like alternate universe California without CEQA that we could observe. Sometimes economists will create what they call a synthetic control. They'll try to like create a composite of different states that have characteristics that are kind of similar to the state they're interested in. But California is so weird and strange. Like there's no way to even plausibly create like a composite of other states without CEQA and say, well, that's what would have happened in California without CEQA. So I think that as much as we want to put numbers on the CEQA problem, like I'm really skeptical that we can do that in any way that is credible. And so again, I think to the degree that we can learn about the CEQA problem, we're likely to learn more from, as soft as it might seem, anecdote and study of the law itself.
So you seem to be taking inconsistent positions. One, we don't know the magnitude of the problem, but your fundamental suggestion about the trigger, about this may have an effect, is a gigantic structural change in the law. Can you help reconcile those two views?
So what I'm trying to say initially is I think that CEQA rests on an outdated assumption. And then
but you're taking the infrastructure of CEQA and driving a nail through its heart, which is the trigger mechanism of it may have an effect. And do you have a suggestion about how to solve that problem?
We're getting ahead of ourselves here. So I'm not.
Well, we're here to listen and get advice.
But I'm not suggesting that we change the fair argument standard. That's not across the board. That's not my suggestion at all. I think the fair argument standard is an illustration of CEQA's core assumption about the relative risks of change versus maintaining the status quo. But the further question is like, well, we've got this outdated assumption. Is it a problem in practice? And I'm saying to you that I think it's hard to answer with numbers that question of how much is it a problem in practice. Yes.
Professor, one thing you talked about is a lack of information from settlements.
Mhm.
I assume that's because both sides want it confidential? Okay, you don't know, I don't know. Oh, regardless, what if we were to recommend legislation that would affect that? In other words, this is a public thing that's going on. What if we required any settlement to be made public?
So I've actually wondered about that. Could you have a rule that said non-disclosure agreements in settlements of CEQA litigation are unlawful? How would that play out? You could almost think
I
of
don't
it.
want it to see it as a crime. Yeah.
Think of it as
I would say though, I just want to add, a public agency can't do an NDA. So, I mean, and you're suing public agencies and the private practitioner. So what you're talking about is before it gets to the public agency. So
Yes.
just wanted to add that.
Thank you.
Yep.
Yeah, but that's the practical reality is that the litigation for most things like housing is not, the public agency may be involved, but it's the developer who's paying for the environmental studies and it's an opponent of the housing.
Not always. A lot of times it's the agency that's paying. I mean, it works both ways. So I'm just, it all depends on what the deal is, who's paying, you know, it's not always that the private practitioner is paying.
So anyway, if settlements were publicly available, that would be interesting. Still wouldn't tell us anything though about the projects that weren't proposed in the first place because of CEQA risk, and it wouldn't tell us anything about projects that were proposed in a different form, like a smaller project or a less dense project because of the CEQA risk.
But doesn't it have a substantial effect if people knew this was going to be public? I mean, I would think that would be helpful to you as a researcher and to others and for the public to see, all right, who benefits by this settlement? And I don't want to argue this part any further. You can move on.
It's an interesting idea.
Commissioner, I'm going to poke a little bit here
Okay.
and just say that I don't know what it even means to settle. If I'm deciding that I'm going to make a contribution to, for example, Earthjustice, is that a settlement or is that just my normal course of business? So, I mean, like everything about CEQA, it's a little more complicated than you would think on its face. So I don't know what it means. I mean, I know in a court when there's a settlement, I know what that means.
Sure.
But I don't know in the full CEQA context where you're talking before the case even before it becomes a case, but it's still project. I don't know what that means.
Like a contract with an agreement not to sue you could say would have to be disclosed, but then.
But who knows?
Then it might be something that's not a contract, right? It might just be something that's a donation, right?
Right. Okay, thank you.
Just let me sort of try to get the gate to the corral here. I understand you've got 4 more slides to go through, and we do want to hear from Mr. Hecht. So if you would go
Okay,
ahead.
so let's go to the next slide, please. And you can put all the content of the slide up. Thanks. So, okay, so why do I tend to think CEQA is a problem? One, from talking to people who are working with it day to day. Second, from knowledge of the doctrine. There are ways in which CEQA departs from what I would call normal administrative law doctrines or deference, both at the fair argument test, that's the trigger for an environmental impact report, also in court's willingness to review an environmental impact report and substitute the court's own judgment for that of the lead agency as to whether it discussed an issue in sufficient detail. Third, and even more importantly, the consensus opinion of legislative insiders on the obstacles to large-scale cost-lowering CEQA reforms. We've been able to do CEQA reforms, a lot of CEQA reforms to the legislature on housing. We have not been able to do cost-lowering CEQA reforms. That is, CEQA reforms that would allow housing to be built inexpensively, right? What we see in the housing area for CEQA reforms are reforms that come with union labor requirements and requirements for a substantial share of deed-restricted affordable housing units. Those are ways of keeping the cost of building high. and rewarding groups that have used CEQA for non-environmental purposes in challenging housing approvals. And it wouldn't be hard if CEQA weren't a good like all-purpose tool for foisting costs onto development projects. Like it wouldn't be hard to do CEQA reform through the legislature, because there wouldn't be like, why is the organized opposition to CEQA reform, the non-environmental opposition to CEQA reform, so vehement? It doesn't make any sense unless CEQA were a good all-purpose tool for making development costly. And then finally, when it comes to CEQA and housing specifically, the effect of CEQA is to confer one-way political discretion on city councils to delay indefinitely the same projects that state law says the city cannot deny or downsize. And that's a big, big problem. And it's a problem that I don't think people really appreciated until San Francisco, first as a city and then as a superior court, laid out the roadmap for everyone else to see. But the bottom line is that the state, through the Housing Accountability Act, has established strict limits on cities' abilities to downsize or to deny a zoning compliant project. State, through the Housing Crisis Act, has established strict limits on the total number of public hearings a city can hold on a housing project. And the state, through the Permit Streamlining Act, has established strict time limits on the amount of time that a city can spend making a discretionary, in part, permitting decision. But all of those limitations depend on the city first completing its CEQA study. And what San Francisco demonstrated is that if the elected governing body of the city, which under state CEQA law is the CEQA decision maker, the final CEQA decision maker for the city, if the elected governing body doesn't want to approve a project, they can just take that environmental study and say, do more. We want this additional thing studied. We don't think this study was comprehensive enough. And if a proponent of the project then goes to court and says, this is ridiculous, the environmental study is just fine, the project's ready to be approved, the court will say, we cannot hear your case. Because until such time as the city certifies its environmental review is complete, the case isn't ripe for adjudication.
What are some examples of cost lowering CEQA reforms? I'm part of a committee that advises Mayor Karen Bass on her housing programs in LA, and the entitlement review and the process has been cited as one of the obstacles to fast tracking affordable housing in Los Angeles. I'm just curious if you've studied some of those examples of cost lowering reforms.
Well, in Mayor Bass's case, she would have the option to make review of any type of housing project ministerial. And if she persuades a court that it's not just ministerial in name, but ministerial in fact, meaning that the permitting agency has no discretion to respond to any of the types of concerns that might be addressed in an environmental impact report, then she will have succeeded in making that class of projects exempt from CEQA. What CEQA takes off the table is the option for Mayor Bass to have a review framework that allows her to exercise some discretion, or her agents to exercise some discretion, without also empowering any opponent of the project to use CEQA as a means of delaying the project approval.
Thank you.
Next slide, please. Actually, you can skip ahead to next slide after this, if you would. So the last thing I want to talk about a little bit is who can fix CEQA. In principle, the legislature should be doing most of the CEQA fixing. There's a great example from the state of Washington where both houses of the Washington legislature just voted nearly unanimously to exempt zoning compliant housing projects in urban growth areas, in areas designated for development and approved by the state from CEQA. But in practice, I don't think we're going to see great CEQA reforms through the legislature in California, given the politics. And so I think to a substantial degree, the governor and maybe even the courts will have to play significant roles. And I can talk more about those roles, but we've gone well over the time that was allotted for me, and I would like to hand the floor to Sean.
Perfect segue. Thank you. Did you? Thank you.
Thank you. So I'm going to start by just saying I'm having a little bit of a health. Are you having trouble hearing me? I'm having a little bit of a health issue right now in the moment, which is ill-timed. So if I lose my focus, please bear with me. CEQA has, of course, become a flashpoint for public criticism, but I think it's important to provide some context for the conversation about the value that CEQA continues to have in today's environment. It's important to note that CEQA applies not just to housing, of course, but to decisions to undertake oil extraction near where people live, to decisions to build or expand port terminals or logistics centers that have a ton of freight that comes and goes, and diesel truck trips. It applies to certified regulatory programs like timber harvest permits and pesticide regulatory decisions. And CEQA over time has unquestionably improved public health and environmental outcomes. Without CEQA, we'd know much less about cumulative pollution burdens on communities, emissions from industrial and commercial projects, and a lot more. And it ensures that the political process is informed by stakeholders who are able to participate. There's a long list, and my footnotes have some of them, and you'll hear from others today, I'm sure, of projects that have become models for how to mitigate impacts because of CEQA, including models that become state of the art and wouldn't have been identified or implemented in the absence of CEQA. And I want to give, I want to note a couple of things in relation to that. It's the primary and sometimes the only legal tool available to historically and currently disadvantaged communities to protect themselves from health harms. This is why environmental justice advocacy organizations support keeping CEQA in, without major reforms. And it's why the California Attorney General, which created an Environmental Justice Bureau a few years ago, uses it as its primary tool to protect communities. Important just to keep all of this in mind for context.
Professor?
Yes.
I have a couple of questions for you. And candidly, Professor and I have had some interactions. I worked at the Port of Los Angeles. He worked for an organization that oversaw some port activities. So just putting that on the record. As you go through this and you're pointing out that it's not just housing, are you suggesting, not suggesting that there should be different rules for housing versus others?
Well, I mean, there are different rules that have been evolved, as you know, Commissioner, for housing. And I think, I'm reluctant. I can't take official positions on behalf of Earthjustice, but personally, there are ways in which I think some of the housing streamlining has been valuable, and I could imagine more housing streamlining. What's notable to me, and I said this in my written remarks, is that there are many types of proposals for CEQA reform that have been proposed that contend that allege to be targeted at housing, but that in fact, when one looks at the details, they're not targeted at housing or at infill housing. And so I think, for example, and this goes to Commissioner Buisa's previous comment, there are tools like the City of Los Angeles's Transit-Oriented Communities Ordinance. Tools like that provide a really different context for housing, and we need housing density. And so the short answer to your question is that in many cases, the answer to your question may simply be yes, that we may need different rules for housing.
But so let me poke at that just a little bit.
Sure.
The law in and of itself is supposed to be blind. Justice is blind. Do we have a problem with CEQA, the law, picking and choosing winners?
Picking and choosing winners in what sense?
Well, in the sense that a housing project may be streamlined, a stadium may be streamlined because of political positions, but other infrastructure projects may not be because for various reasons. So I'm just, your thoughts.
So I think that there's pretty widespread agreement that CEQA exemptions on a case-by-case basis, like a bill aimed at building a stadium, is not a successful way to make policy in the long term. So I think that that piece of it seems pretty clear to me. The question of whether in other contexts, like broadly, it is more valuable to incentivize dense housing than to incentivize, creating more oil drilling projects near where people live. I think it's perfectly reasonable and in fact, good public policy to incentivize one and not the other, whether that's through CEQA itself, or whether it's through other laws. So, and I think that's even true with housing, that all housing isn't created equal. We're not going to solve our housing crisis, and we didn't solve our housing crisis in previous relative booms by building McMansions next to golf courses. But we will solve our housing crisis in other ways, like denser housing. I'll also point out, and I said this in my written testimony, that sometimes the most affordable housing, the most deeply affordable housing is housing that already exists. And so I provided an example in the San Bernardino County area of a project which is going to demolish by the terms of the proponents over 700 units and displace over 2,500 people. There are numerous organizations, including Earthjustice, that have been involved in saying, well, hold off, and using potentially CEQA as a tool in order to address the impacts of that on housing. And so to say simply that CEQA that CEQA is an impediment to new housing does not give us the entire picture, even of that.
I didn't say that.
Right.
I just want to be clear.
Understand. No,
Okay.
I understand, but I'm just kind of giving an example of the ways in which this is a complex story, right? It's a story where I think it's very easily caricatured, and I'm not suggesting you or any commissioner is doing this, but I've seen, and I suspect we may hear even today from folks whose views of it I do consider to be caricaturing it. If we characterize it, infill as anything built within any city's jurisdiction, period, including, cities that are, not dense at all. We all know that city means a lot of things in California. City means Palos Verdes Estates, and city also means Maywood in Southeast Los Angeles County, and they're very, very different kinds of places. And so I think we should be really careful as we think about what we're incentivizing. If we talk about, and I think it's not only legitimate, but I think it's important to make choices about what we incentivize. And if what we want to incentivize is certain types of dense infill housing in particular places, the law should do that, and it should not also incentivize sprawl housing if that's not what we want, and I'd contend that it's not what we want. And it should not incentivize other types of commercial and industrial projects being streamlined out of CEQA. Not that we don't need sometimes some of those projects, but some of the examples that I've given are situations where it's really essential. And again, thinking about its impact on CEQA's impact on communities, we see, for example, the only reason, as you know, Commissioner Sidley, that the port in the early 2000s, certainly before I became involved in that work, the reason that the port was incentivized to do true environmental review was because of advocacy under CEQA. You may disagree.
I totally disagree. So we don't have to go there. But I want to ask you. And I'll point to the CEQA documents out of the port that I'm familiar with. There are thousands and thousands of pages of very, very complex information. This is a public disclosure law. Is that actually, we talk about underserved communities, and this is their only tool. I would submit that without someone like you, a professor, without highly paid experts, without help, that's not helping anybody. And if a community can't get someone like you to come in and help, then CEQA is not actually doing its job.
Yeah.
So is that the proper tool to keep your fingers crossed that I'm going to find an Earthjustice, an NRDC, Center for Biological Diversity to come in and take an interest? Otherwise, I have working families who don't have time to go to all these meetings, to do all this, to read an incredibly complex document where you need to be a PhD to even understand what's going on. So is that the best tool?
Sure. So environmental documentation is by its nature technical. I mean, certainly those of us who are lawyers who work in the environmental field are well aware of that. And I don't think there's any way around the technical nature of that. What I'll say is I think in the 1970s and 1980s, CEQA was a much harder tool for exactly the reasons that you suggest for communities to use to protect themselves. And for the resource constraints that you've mentioned, there weren't organizations like Communities for a Better Environment that were willing and able and had the resources to take on these cases in those days. I'd suggest, and I'm certain that this is true, is that the capacity of the public interest environmental law community and advocacy community more generally has grown dramatically, and its orientation towards protecting environmental justice communities has also increased dramatically over the last few decades. And so if you look more recently at the work that those types of organizations are doing, you will see them focused on community protection in a way that, you know, I would suggest, you know, in the 1970s probably wasn't so true. And I think that that's a good thing. And I think the, again, by its nature, environmental review of any kind is going to be technical. And without CEQA, it would still be technical, but there would be less review and less mitigation.
Is that a form of NIMBY that's just moved to a different community?
Well, I guess I would say, I mean, so the word NIMBY, of course, is a loaded word. To me personally, and I think that this is, it's not just my personal view, but I think of it as sound public policy. There's a really big difference between communities that have been subjected to decades of cumulative impact and environmental overburden using legal tools to protect themselves than a community that you know, has dedicated itself for 50 years successfully to keeping anything out of it. And one could call both of them NIMBYs, but I would suggest that those two types of communities are situated completely differently from one another. One of the challenges of using a law like CEQA is that CEQA as a law is agnostic as to that question. But I will also suggest that, you know, and again, you'll hear from others, I'm sure, that it is the primary tool that the communities that are actually overburdened are able to use successfully in order to address these questions. And so I guess I would reject, you know, respectfully the NIMBY label as really being you know, being salient in that context, even though in the most literal sense, folks are still trying to keep things out of their neighborhood. Some of them are folks whose neighborhood has been polluted for decades with multiple industrial uses, like the community of Wilmington, you know, with oil refineries circling it on all sides, with active oil wells and with the port complex nearby. You know, a community like that using environmental laws to protect itself seems to me to be situated very differently from wealthy suburban communities in those senses.
Can I briefly interject here? I believe Massachusetts has a CEQA-like law that applies only to so-called environmental justice communities. I could be wrong about that, but if you're interested in this, you might want to pursue that idea.
Commissioner,
Thank you, Commissioner.
Commissioner Biber has.
Yeah, just to first, thank you for your testimony. Your first paragraph was fantastic about CEQA and what it's accomplished, and we should keep that in mind. That doesn't mean we shouldn't talk about changes. So to follow up on Commissioner Sidley's point, I'm going to raise three, I'll call it structural questions, and I'm going to solution set in the first hearing, and maybe that's premature. Requirement of a bond before you commence CEQA, attorney's fees, fee shifting, and choice of judges, that is which judges get appointed and whether they're kind of just self-selected and whether as a result they're oriented towards being more aggressive or reform oriented within the context of litigation. So those are three things that a legislative activity could engage in that would avoid the problem of housing only fixes. And so maybe you could just respond to those three ideas in 2 minutes.
Well, certainly. So I would be wary of broad bonding and fee shifting type provisions because, again, speaking now on behalf of an organization like Earthjustice, but based on what I've observed, the risk that an environmental advocacy organization would be taking then would be very, very severe. It would cause, because CEQA, the prospect of having to pay attorney's fees to the government or pay a massive amount of money in order to bring an action. As you know, that is not typical in US law. It's reserved for a rare set of situations, typically including enforcement of civil rights laws and things like that. The idea of fee shifting or bonding to put those burdens on plaintiffs, I think would have a real chilling effect on legitimate advocacy, on advocacy that's really essential for communities. And to this point that we were talking about before, I think the very wealthiest communities would still be able to afford to take those risks, and the communities that I'm talking about protecting would not be. I guess on the judge's question, I don't have a clear idea of what a proposal like that would look like. I think if you talk to lawyers on all sides of these questions, they will complain about the way that
what if the judges were chosen for CEQA cases on the basis of, like, the Southern District of New York, where they have a wheel and it's just random, as opposed to judges who hear a lot of CEQA cases and become expert, and their colleagues defer to them, and effectively you end up with a CEQA court.
Yeah.
And yes, it's more expert, but it's also much more oriented to finding new rights, because that's how you make your name.
Yeah. I guess I could see both sides of that question. I see that as not really addressing the core set of questions either way. I think people will find, I think there are pros.
Yes, but the testimony we heard suggests a high degree of judicial activism on CEQA that is pretty unusual for judges to make new policy around a 60-year-old statute.
Yeah.
Can I jump in
Yeah,
here briefly?
of course.
So
Of course.
I think the CEQA judge phenomenon is quite interesting. So it's the case that most of the superior courts have a specialized CEQA judge. And there was an interesting discussion of the role of the CEQA judge in a recent opinion from the Court of Appeal in, I think it was the Marin case, City of Tiburon, County of Save Tiburon, something or other. Anyway, I can provide it to you. In which the Court of Appeal said, in practice, even though the theory is that we review the decisions on questions of law de novo from the beginning, in practice, CEQA is so complicated and the CEQA judge has so much expertise that we give practical deference to the view of the CEQA judge on questions of law. And that is really different than how normal administrative law works, where the Court of Appeal will look at questions of law and work them out. But if it's like an arguable factual question, or you can kind of go both ways on it, usually the agency gets deference. That said, most of the sort of expansive interpretation of CEQA that have made it what it is today has come from the Court of Appeal or the Supreme Court. So the CEQA judge phenomenon may explain kind of the teeing up of questions for the Court of Appeal, but the Court of Appeal, once the questions have teed up, has been very eager to eat the dinner, or whatever the metaphor is.
I agree with that broadly. And I would also say that there are many appellate districts where there's a lot of reversal of trial court decisions and a lot of new law that's being made. I guess the other thing I'll suggest, and again, I don't have a strong opinion either way about this, but I will suggest that if you talk to lawyers who practice in this area, CEQA practice is its record review. It's what's called in some parts of the state writs and receivers. It's a very different kind of practice. Judges are not hearing evidence in court, and non-CEQA judges can struggle with it for that reason. I mean, there's value to having that expertise. On the other hand, I think many people will tell you on all sides of these questions that there are, if there's only one or two judges who hear particular CEQA cases, and in circumstances where litigants do think they can predict how judges are going to rule, that does create its own perverse incentives for litigants. And so, again, I don't have a strong opinion either way, but I see pros and cons to that.
Your point is well taken. I was involved in writing the statute that created the Court of Appeals for the Federal Circuit, reviewing all patent cases. And that was thought to be great because they would know how to deal with these cases. Then the Supreme Court said, but they're dealing with them wrong, and reversed them like 5 cases in a row. So the pendulum swings back and forth on that.
I believe Commissioner Cannella at that end has.
Yeah, just a quick question on the attorney's fees. As I recall, there's almost an incentive to throw everything, including the kitchen sink, at a project, because if let's say you bring 100 counts on a project and you prevail on one, then the attorney's fees are for the entire 100. Is that correct?
Courts have quite a bit of discretion about how to order fees. I've certainly seen courts in many cases provide fees that relate to prevailing claims. I've seen courts that do take more of the approach that you're talking about. I don't think that there's one way to do that. I think that one of the advantages for CEQA plaintiffs' lawyers of bringing a range of claims is some of the uncertainty about how courts are going to view the questions. And, regardless of fee shifting, there's value to actually winning the case if winning the case, it provides value for the plaintiffs in the case. So I'm not sure that the fees are what drive that question, but I think, I would be surprised if fees, rather than the prospect of actually having more possible reasons to prevail in the case, were what drove that question.
Okay, I'm a civil engineer, and we work with CEQA all the time, and it's usually less about organizations like yours coming in to protect the public. It's usually other reasons my experience that they come in, whether it's maybe a project labor agreement, maybe it's a one business fighting another business, and really becomes somewhat of a delay tactic. And so then they throw all these things that have to be worked through. And so it's just, I like CEQA. It's a disclosure document. There's nothing wrong with CEQA by itself, but when it becomes abused and delays projects, it's very expensive. You really have to be a fairly well-funded person to process a big project, because you're going to do a EIR. It's going to take 18 months, and it's going to cost $500,000 to $1 million, and that's just for a 200-acre project. So I hope that in the legislature we couldn't fix it. We tried. Governor Brown, who's probably one of the strongest governors our state's had in a while, wasn't able to do it. So hopefully we can come up with some tweaks that just make it a little easier to get projects approved. So,
Jeff, thank you, Mr. Hecht. We're looking at 10:30. We've got another panel with 3 witnesses. I don't know how much more you have.
I guess I'll just make one or two more quick points. Professor Elmendorf mentioned, trying to tackle the new world of addressing climate change as being a very key question. And I agree with that is a key question that governments have to face. Again, as I mentioned in response to a prior question, CEQA can be and has been a tool for actually helping to address that in the adaptation context. It also has been a tool in the climate mitigation context, GHG reduction. And I think, I said this in my written testimony, and I want to remind folks that way back in 2006, the reason that most local jurisdictions in the state were spurred to do local climate action planning, inventorying their greenhouse gases, incorporating greenhouse gas plans into their general plans, which meant looking at transit and density in a different way, was the settlement of a lawsuit that was brought by the state of California Attorney General's office that required the county of San Bernardino to go back and consider those things specifically in its general plan. There were just a very small small number of jurisdictions that were doing that voluntarily at that time. And it caused quite an uproar. There were local governments that were very frustrated that they were being, in their view, forced to actually look at greenhouse gas emissions and density and transit in a different way in their general plans. But it was, in fact, a CEQA lawsuit that motivated that, brought by both the state attorney general and the Center for Biological Diversity, if I recall correctly. And so, and it continues to be the case that there are applications of CEQA that actually support sound planning in terms of greenhouse gas emissions. So I wanted to just make that that one other point. The last thing I guess I'll say is that and this echoes some of what Chris was saying, but is a little bit different, is to be skeptical of the empirical research. And again, playing around with definitions like what is infill, or looking at limited sets of data that we have available that might not include everything, often will lead to conclusions that are not well supported. And so, again, particularly conclusions like most challenges against, most CEQA challenges are against infill housing. I have not seen true support for that claim. But again, I think the key is if you're going to think about CEQA reform specifically to address the housing issue and the density issue, looking in a targeted way about how to give local governments those tools, or potentially to take away tools from local governments that might impede that housing, are options that really in the end are not about CEQA itself, but are about local government decision making. And just one very last point on that I mentioned that the State Attorney General's office has worked to enforce CEQA. It's a pretty significant chunk of their work. They also filed a lawsuit against the city of Huntington Beach, which many of you may be familiar with, just a couple of weeks ago, attempting to get the city of Huntington Beach to not do some of the things that Chris referred to. I haven't looked closely at that lawsuit, myself, but it's noteworthy to see that some of the problems that are being attributed to CEQA might just be local governments using all the tools that they have to try to keep housing out of their communities, or denser housing out of those communities. And I think it's important to keep that distinction in mind if we're thinking about making changes to CEQA in particular, and to think about what other changes we might want to make that are not about CEQA if that's the thing that we want to target.
Thank you. Vice Chair Varner.
Thank you. Thank you for your testimony. This kind of circles, it dovetails in what you're just saying and what Commissioner Cannell was saying earlier. So we had testimony here, I guess it was a couple of years ago, with regard to affordable housing. And one of the comments in it was that the uncertainty created by the regulatory scheme you have to go through in order to get a project approved. This timeline was 20 years plus sometimes to get a project approved. And they said that there was only a handful of businesses or developers that could actually afford that. And so my concern is more of limiting the ability to go out and develop a housing project to just a handful of big developers. And some of them now are all just coming from Texas. They're well funded. And we have, we did a study just recently on equitable economic development. And I would think that I don't know how we would do something in the regulation to help this, but I would think that people who are within their communities that want to build a housing project within their community could afford to do so with some sort of certainty with regard to their funding. And so I guess I'd like to expand upon Professor Elmendorf's thought process of having some exemption through zoning regulations or something within a community, say, especially when you have the regional housing assessment needs, or regional housing needs assessment that you're like the city of Riverside is told you got to build 44,000 houses. How are we going to do that in the city of Riverside when we've got to go? We don't have the infrastructure for it, the transportation, the jobs, so that you don't have the VMTs going through the entire part of Southern California. There's a lot of disconnect, I think, with the regulation and what's the requirements are out there. But if you did something where there was some specific area within a community to say, this area is zoned for affordable housing or multifamily housing, and it's exempted from CEQA as long as it's gone through some sort of process. Is there a way to expedite that? I don't know, but I'm curious about your thoughts on what Professor Elmendorf was suggesting.
I mean, I think of myself as being very out of my expertise in thinking about what incentivizes housing in the places that we want it and what doesn't. So I'm sure you'll hear from others who have a better sense of that. Again, I mean, what I am familiar with is tools like the transit-oriented communities law in Los Angeles, some of the other streamlining laws that we've had. My sense is that I think Professor Elmendorf may disagree with this, but my sense has been that there's been some success at that. Anecdotally, where I live in Los Angeles, there have been areas that have been empty or underdeveloped for decades, that since about 2016, there have been thousands of new units that have been built, which makes me optimistic that that can be done. I think some of the data, and I think Professors O'Neill and Biber may talk about some of this, that demonstrates that jurisdictions that want housing have figured out how to build housing in a more streamlined way. That also might be useful to try to figure out like how much it is the particular political preferences and decisions made by jurisdictions that want to keep housing out, and how you deal with that. But on that core question of how to make it more affordable and what sort of streamlining works, and the economics of that for developers, I confess I'm the wrong person to ask for detail on exactly how that operates and how it could be improved. I do think there will be people talking later today about that same question, and I'm sure at your other hearings. But I have to demur a bit on that question because it is outside of my own knowledge base.
All right. It looks to me as though we've exhausted both of you.
Can I just say maybe one final remark?
One final remark.
One final remark is I think Sean and I are broadly on the same page with respect to one concept. And that concept is, let's identify the types of projects we need to do for environmental purposes. Electrical transmission, maybe new solar farms, maybe housing in defined urban growth areas, and let's scale back CEQA's application to those projects. We might differ on some particulars, but I think broadly speaking, trying to identify the class of projects is going to be more productive than trying to establish like bonding requirements that apply across the board to all CEQA claims, or fee shifting requirements that apply across the board to all CEQA claims.
Yeah, I mean, I would say even with those proposals, the devil's in the details about exactly what it looks like, right? And so, but especially as to housing and renewable energy, as to dense housing and renewable energy, I agree that there's a lot of value to thinking about how to, if you're going to make reforms, to think about how to target those reforms in a way that does not also sweep in streamlining of CEQA review for things that are actually harmful to communities where it makes sense for communities to have a voice.
Yeah, I mean, fundamentally, the answer to all this is voter registration. Ultimately, it's voter registration. It is people who are empowered in communities that exercise the right to vote, that then elect people who reflect the perspectives that they want to see. Because absent that, what you're really asking for, in a sense, is for legislators in Sacramento to create some kind of imposition, which will be resisted by the locals. And so long as the local electeds are not chosen by a broad perspective of people in the communities, there will be minority perspectives that influence decisions that city council and board of supervisors make. Because that's part of what we're talking about here. We're talking about land use planning, the general plans developed at the local level that impede or make more difficult particular objectives that we want to pursue. And the notion that we need a scalpel instead of a sledgehammer is one that I think we could agree, but then it's all about whose hands on the scalpel. So let's thank you very much for
Pedro,
your testimony.
Pedro, if I could also, just to both of you, thank you very much. Thank you for indulging my questions.
Of course.
I think it's important to poke at this as we're at a hearing and we want to learn more. So you will not be the only ones that I poke at, but I think it's important to ask those questions. And I think it's important for everyone else to hear your answers. So I just wanted to personally thank you because I know I'm the one who's doing most of the poking here.
Well, thank you. I appreciated all the questions. I mean, I appreciate the attention that the commission is
Thank you.
giving to
Thank you
this
both.
entire
It's very helpful
issue.
to us. All right, Ethan.
Thank you.
Thank you, Mr. Chairman. Our next witness, who I will ask to come up now, is Laura Tolkoff. Ms. Tolkoff is the Transportation Policy Director at San Francisco Bay Area Planning and Urban Research Association, also called SPUR. In that role, she works to make walking, biking, taking transit, and carpooling the best ways to get around the Bay Area. Ms. Tolkoff has worked for SPUR on transportation and land use policy since 2015 in various roles, overseeing strategic, local, and regional initiatives, and also serving as SPUR's first San Jose policy director. Before joining SPUR, she was with the Regional Plan Association in the New York metropolitan area during and after Hurricane Sandy. She has a master's degree in urban and environmental policy and planning from Tufts and a bachelor's degree in media studies from UC Berkeley. Ms. Tolkoff.
There we go. Thank you so much for the introduction. Good morning, commissioners. My name is Laura Tolkoff. As you just heard, I serve as the Transportation Policy Director for SPUR. Next slide, please. SPUR is a nonprofit urban policy organization that works to make the Bay Area more sustainable, more equitable, and more prosperous through research, education, and advocacy. Thank you for... Is this a little better? Okay. Thank you for inviting SPUR to speak today about the relationship between CEQA and sustainable transportation projects. SPUR co-sponsored a bill that created a statutory exemption from CEQA for a selection of target of sustainable transportation projects in 2020 called SB 28 with Senator Wiener, and its successor when it expired or sunsetted SB 922 just in 2022. So my testimony today is really actually going to focus on smaller, less capital intensive transportation projects, those that are sustainable, active transportation projects, and some types of transit. In our view, CEQA is a critically important law for protecting California's environment and people against harmful projects that pollute natural resources and jeopardize public health, especially for disadvantaged populations and those that already experience high pollution burdens. However, as designed, CEQA presumes that all projects are inherently bad for the environment, when in fact, the climate emergency demands that we double down on some types of projects that reduce driving and greenhouse gas emissions, such as transit and other forms of sustainable transportation. As you know, over 40% of our emissions in this state come from the transportation sector, and the majority of those are from passenger vehicles. People drive and pollute less in places with high quality transit, bicycle lanes, and sidewalks. And bringing down our transportation emissions by providing more sustainable options has to be part of the solution to limiting our global warming. CEQA requires state and local agencies to evaluate and disclose the significant environmental impacts of projects that they approve and to avoid or mitigate those impacts if feasible. The evaluation is the basis for many state and local approvals needed to build and deliver a transit or sustainable transportation project. Each step of the CEQA process is subject to appeals and lawsuits that can increase project costs and create delays. The law allows anyone to appeal or sue a lead agency's decision to approve a project under CEQA unless it is exempt from CEQA's requirements. Next slide, please. There are two types of exemptions. Oh, wrong, never mind. Keep going. Okay, so there are two types of exemptions from CEQA, a categorical exemption and statutory exemptions. Categorical exemptions apply to categories of projects that generally do not have significant environmental impacts. However, even with a categorical exemption, the lead agency must first undertake significant analysis to prove that it is exempt, and the project can still be challenged through appeal or litigation on the categorization or due to any unusual circumstances about the project that would make it different from the exempted class. In short, a categorical exemption provides very little assurance or protection for projects in its class. For example, as part of its COVID-19 emergency response in early 2020, San Francisco planned to install temporary transit lanes and emergency bikeways using a categorical exemption. However, the project was appealed explicitly due to the associated removal of parking. We've heard a number of agencies report stories like this, and it can take up to 6 months to resolve appeals to the local governing body, and 3 to 4 years and millions of dollars to resolve a single lawsuit. The second type of exemption is a statutory exemption, which describes projects or types of projects specifically excluded from CEQA requirements by state law. Unlike categorical exemptions, statutory exemptions cannot be challenged easily through appeal or litigation, and the lead agency need not conduct that initial study to prove that it is exempt. A statutory exemption provides a lot more time certainty and cost savings than a categorical exemption. As shown in the figure behind you and in the testimony, there are actually very few exemptions for sustainable transportation in the law.
So as you're going through your testimony, are you advocating for more things to be exempt? Is that, or are you advocating for, I know I'm jumping, I'm sorry.
You are.
But I'm sorry, but it goes to Professor Hecht as well, where he, is housing a particular category, are bike lanes a particular category, and at what point do we stop carving it up as a policy matter versus we have a statutory framework that we all can live under?
Well, I'll tell you what SB 280 and 922 did was create a targeted set of exemptions for certain types of projects that we know are beneficial for the environment. If I were to suggest additional changes to CEQA, what I would suggest there's a couple of things that I would suggest relative to these types of transportation projects. The first is to eliminate sunsets on the statutory exemptions that we have. They currently expire in 2030, and that was after only a 2-year sunset. We were able to win a longer one till 2030. The second thing, and I might want to come back to this particular issue because I think it requires a little explanation, which is that we need to provide some distance, I think, between good planning and the environmental disclosure process. Right now, CEQA tends to be the default planning process, at least for public transportation and for active transportation. That's not how it works anywhere else in the world. And I think this is a place where it would really require a bit more distance. I think we can keep going on this, but another thing, NEPA and CEQA alignment. A lot of transportation projects, especially a larger one like a bus rapid transit project, would require federal funding in most cases, therefore making it subject to NEPA. So you could talk about CEQA and NEPA alignment, though, that's quite a stretch. I think what is within California's power, however, is to fully fund certain types of projects so that it is not subject to those federal requirements and has the streamlining benefits that are already in place today.
So let me ask another question in relation to zoning. And so zoning is usually a local decision. And let's talk about the Huntington Beach lawsuit that was just brought. And I'm going to give you the framework. You don't have to have read it at all. At local decision is not to do particular type of housing. The state has a different view. At some point, is this state law a good tool to promote state policy versus local zoning? Is that a fair question for you or not exactly where you're going?
So in general, I'm not going to speak specifically about housing today. However, I do think that there is a role for state law to make it easier for local governments to do the things that they actually want to do. So I'll give you an example. I think we heard the prior speaker talking about how there are lots of good projects incorporated in plans, but a plan is just a wish if the projects can't get built. And I think that's the reality, is that you have a lot of projects that are getting scaled down or not built at all because of, in part due to CEQA challenges. So I do think that there is a role for the state in this.
And maybe also not in your purview, but to Commissioner Varner's question is the cost, and also Commissioner Guisa, the cost. Are we taking minority women-owned businesses out of the equation because of the upfront costs of CEQA, and people can't get the proper funding? They can't actually get in the game to participate in the economic process because of the upfront cost. And so we are relying on large developers outside of the state. And I know you're talking about public transit, but even at public transit, are you seeing that those who are, are we somehow disadvantaging smaller minority-owned business, women-owned businesses because of those upfront costs?
So all of the types of projects that I'm talking about today are public works projects.
Okay.
So they're sidewalks, they're bike lanes,
Okay.
they're signal changes. So that's the focus of my testimony today. But there are very real human costs to this, which I think is what you're getting at. So I'll speak to that in a moment. I do want to turn your attention back to the table from OPR on the screen, which is that, this is the list, a comprehensive list of all the exemptions for public transit and sustainable transportation that exists in the state. And the ones on the left, from PRC 2180, those were done in 1972. Until 2020, there had not been an update to CEQA for transportation projects that we know are beneficial to the environment. And so, much has changed since 1972. We know a lot more about our climate crisis. We know that California is experiencing compounding racial disparities in access to opportunity and mobility and exposures to pollutants, and clean transportation has to be part of the solution. The other thing I want to say here about the human cost, Commissioner Sidley, is that there is a real human cost when projects and plans are held up by CEQA. CEQA litigation on San Francisco's bike plan a few years ago held up 34 miles of bike lanes. Next slide, please. And during that time, 9 people died. 2,000 people were injured while riding their bikes in the city. And this continues. This isn't a past problem. In 2020, the city's Slow and Safe Streets program was appealed, even though it was a cornerstone of the COVID-19 recovery program, a cornerstone of Vision Zero. And, in both cases, both the bike plan and the Slow Streets program, the appeals were not grounded on legitimate environmental concerns. They were based on the removal of parking. Now, I buried my friend in August, who was killed by a driver on the streets of San Francisco. He's the father of my 4-year-old's best friend. I cannot unsee the look on his children's faces or on his widow's face. And there is no plan, there's no justification that's going to bring him back, and especially not one that says it was because of the removal of parking or because it was a CEQA plan under appeal, right? That's never a justification. But there's a real human cost. And oftentimes those delays are caused by individuals whose narrow interests play an outsized outsized role in project decisions that benefit the public. For example, the East Bay Bus Rapid Transit Project was likewise compromised when a single business owner in Berkeley threatened to file a lawsuit under CEQA over parking losses. This forced the project sponsor, AC Transit, to significantly scale back the project to run only between Oakland and San Leandro. And this left people who are in some of the most disadvantaged neighborhoods like East Oakland without an affordable, high quality, and efficient access to jobs, schools, goods, and services in the East Bay, which makes me question who is being protected. And then I really want to give this as, I think this is a really important illustration of what one of the prior witnesses mentioned, which is, there are countless projects that you can only kind of see through the stories about the collapse of ambition and the ways in which we scale back projects because of these threats of litigation and who do they harm. So our hope is that CEQA could be modernized with targeted and goal-oriented updates that reflect the important role of clean and sustainable transportation in reaching our climate and our health and our equity and mobility goals. Next slide, please. And that's really what we did with our partners, the Bay Area Council, the Silicon Valley Leadership Group, and the California Transit Association, working with Senator Wiener to pass SB 288 in 2020 and its replacement 922 in 2022. And in creating our new exemption from CEQA for sustainable and active transportation projects, our goal was to avoid any loss of environmental protection and maximize the benefits associated with these types of projects, while also ensuring that there actually is a meaningful process for public participation to advance procedural equity. So SB 922 provides targeted statutory exemptions for several classes of transit and active transportation projects, as you see listed on this slide, which would significantly advance the state's climate, safety, health, and equity goals. I'm not going to name all of them here for the sake of time, but it is purposefully designed to offer no benefits to projects in greenfield locations or for the construction of roads and highways, which would be detrimental to the environment. And it is specific to urbanized areas. To qualify for the exemption, they have to meet a number of criteria that benefit the environment and communities. For instance, SB 922 includes provisions that project sponsors meaningfully engage communities in shaping those projects and require careful planning to benefit residents, including requiring a racial equity analysis and a residential displacement risk analysis for qualifying projects over $100 million. This is the first law to actually update CEQA with procedural equity, given that we know that CEQA is often weaponized by wealthier and wider individuals to stop and delay projects. And again, I want to reiterate, we need good planning, we need good environmental disclosure, and one should not subsume the other. These exemptions that we created are good policy and they are working. In an early assessment of SB 288, about 6 months after the law was passed, we found that the exemptions had been used to advance critically needed and community-supported sustainable transportation projects. Next slide, please. Most projects that have used the exemption are actually small-scale improvements, just like the ones that we intended them to be for, those common sense projects for walking and biking that otherwise would have taken longer and cost more. Many transit agencies also are trying to use the exemption and needed it extended in order to comply with CARB's ICT rule, which would speed up that transition to zero emission transit vehicles and remove local pollution. 60% of the projects that were identified as under construction were those that were for compliance with the ICT rule, either by modernizing the bus yards or actually the fleets themselves. The innovative clean transit rule, it's a Yeah. And this slide shows, in those 6 months since SB 288 passed, 15 projects were initiated or completed, 38 more were under consideration at that time, and 11 of them, these small projects were in disadvantaged communities in order to remove pollution and increase access and mobility. Next slide, please. And, I think these are the types of projects that were made possible by these exemptions. So JFK Drive in San Francisco, now Promenade, that only happened because this exemption enabled it to move through ministerially. The pictures on the right are from the Bayview, which is a historically Black and Latino area on the east side of San Francisco. This project that you see here, it was a quick build project in an area that was known as Dead Man's Curve, where a lot of people had been killed, and it made a number of road changes that made it safer. And it was the top priority project in a community plan from the Bayview from a few years earlier. So these are really, it's something that is really enabling the right types of projects to be built that are consistent with the state's vision, and then are beneficial to the environment and the communities that they serve. If you have any other, and I also just want to offer that SPURT does have a few reports about that speak about this, including the one linked in your testimony. So thank you so much for considering my viewpoint.
Thank you. Commissioner Biber.
First, very sorry for your loss of your friend. I guess I want to start with complimenting you and SPUR for applying diversity, equity, and inclusion focus on the exemption structure. It's very impressive, very thoughtful. The broader philosophic question is, you've brought to us a case study about a fix for a very small part of CEQA. And it's predicated on the assumption that you can figure out the specifics within an exemption in a subcategory of activities, in this case, transportation. It begs the larger question of, are there systemic problems within CEQA that should be dealt with comprehensively? And so I'm wondering whether there are examples, and I'll pick one, where we could think through how to apply the lessons from your case study more broadly. And the example would be a requirement that environmental impact reviews have to be updated. That is, you spend the money, something changes, some regulation changes, and then you have to redo everything and the clock starts over. Are there other kind of generic examples that you've run across of CEQA structural questions that apply more broadly than just the transportation sector in which you're expert?
So thank you. I would argue that this actually provides an example of a structural issue, which is that I would wager to bet that there are other types of infrastructure and other policy decisions where you can separate the good from the bad.
Well, one structural thing that you already brought to bear, which is in your advocacy, that unlike CEQA, you can balance benefits with risks. Government agencies do this all the time. The Food and Drug Administration does that with determining a drug is safe and effective. Cancer drugs don't cure people. There are safety risks in everything, in water, in aspirin. And there's a balance that an agency makes. But yet with CEQA, the positives that you're talking about from a transit point of view or an equity point of view aren't really part of the process. That's just a structure of CEQA.
Yeah, so the other systemic thing, again, that I would point to is, the other systemic thing that I would point to that I almost could guarantee would exist in other domains is CEQA becoming the default planning process. Because if so, that's not a good way to do public engagement. It is not a good way to identify community needs. And it also, the other challenge, and this is separate, it's an issue with the bigger public transportation projects in particular is that you, as an agency, they take a really long time to complete. So let's say you have $1 billion project. Now, this is aside from the testimony that I just gave, because we're talking about a very different type of project, right? Let's say you have $1 billion transit project. You're going to have that project regularly spend 10 years going through CEQA because it is your planning process. It is your engineering process by which you get to 30% design and make a lot of choices that have an impact on your customers and on the communities around it. And two things that come from that. Your $1 billion project at 5% cost escalation per year, which is like low in inflationary times, but a standard way of thinking about it. Your project over those 10 years, due to that just simple cost escalation, is $1.5 billion. So, you need to think about that and what happens when when CEQA is so extensive and you fear litigation so much that you now have a lot more money to raise. Your project costs a lot more. And also, you're kind of stuck with the choices you've made, and things might change. So with a big capital project, like a bigger transit project, these are projects that, may have been conceived of 30 years before they ever break ground, and a lot changes during that time, and you get locked into decisions that can no longer be revisited because you have invested so much time and so much money to get that record of decision that you have so little flexibility to change anything. And so I think, thinking about how extensive the analysis is and under what conditions and for what purposes things can be changed would be something I would encourage you to think about.
So, Commissioner, if I could just elaborate on what you said, and please correct me if I'm wrong, but one of the things why you're talking about 30% design is because there is a principle in CEQA, you cannot predetermine the outcome. So if you design your project and you're done with your project design, then the argument is, well, you've predetermined the outcome of the analysis, and that would be a violation. So generally, a rule of thumb is about a 30%. Is that what you're referring to? Yeah. So I'm just to explain to everybody why that number was there. It comes from case law of a Save Terra case. There's been some work done on that, but nonetheless, that's just to explain a little bit about that. And also, I think something to consider, and my apologies for not asking the first two witnesses, but that is you issue a notice of preparation, and then you're going through and you're 90% done with your CEQA analysis, and then a new model may come out. And then there is other case law which requires you to do the most up-to-date modeling. So you've spent the money for a 90% analysis, and then you have to go back and start again. So when you're talking about maybe ways of making a small tweak to save money, if you were to say that once you've issued your NOP, then that modeling is good for a certain number of years, I wouldn't say a lifetime, but a certain number of years, that may allow for a little more certainty that a new state agency is not going to come out with a new model, which may then require you to do some additional very costly analysis. So I'm just, again, it's a hearing for which I want everybody's input, and I'm throwing out this idea, but I wanted to give a little more context to what you've described. And if you have any thoughts about this idea of locking in modeling, I'm curious.
I don't have specific thoughts on that.
I have a quick question for you. Correct me if I'm wrong, but a lot of these transportation projects that some of them are funded by local tax bond measures. So, and I know that some of these upfront costs that go into this, I think county again had a transportation project recently that all the upfront funding was for CEQA compliance. And with that, so from the Little Hoover Commission's perspective, my mantra is always efficiency. That we think about the cost to the taxpayers associated with some of these projects. And I think that there's again, a basis for looking at, I think with your testimony, correct me if I'm wrong, you're advocating for looks at additional statutory exemptions.
I think what I would recommend is some of the statutory exemptions that were just passed with SB 922 are very good, but they go away. And so do we need the sunset on them for these projects that we know are beneficial? That would be my primary recommendation. The second would be, there probably are other projects that would benefit from exemption, and we could tease those out, and that's for transportation, but that's also for, I'm sure, other policy domains. Those would be two big things I would think about. And then again, I would think about the funding. Do we really need federal money to build, to do transit priority, which is actually very inexpensive on the whole, and think about, well, if we have these exemptions and these streamlining here in California, maybe we can just fund it and accelerate those and not have to have NEPA compliance. So that's an important one.
Good, thank you. I see no further questions. Oh, I found it. Commissioner Buiza.
Your testimony, one of the ongoing critiques of CEQA is the law almost always often considers the negative effects from a project without considering or giving equal weight to the consequences when a major infrastructure or project is not built. Some of your examples, like the bike lane, of course, is an example of the consequence of an exception. But do you think, or what are your thoughts in terms of that latter part of my question, giving equal weight to the consequences of when an EIR, for example, doesn't reflect that?
Yeah, so that's really, I think, the central premise between my recommendation to put distance between your planning process and your environmental review and disclosure process. So the way that it works, for instance, in pretty much every other country, and you can look to Canada, right? They do this really well, where they do a business case, and it's actually not a one and done business case. It's multiple business cases where you're evaluating project benefits and costs quite fully. So there's the financial case, the economic development case, the climate case, all of the things related to access, mobility, et cetera. And you evaluate that, and then you kind of keep doing that as the project gets developed over time and before you actually select which project to do, because there's many different possible solutions to a mobility need. Maybe it's a bus lane, it might be a rail line, right? And you have to analyze those and determine which is the best. And that is your planning process where so much more public engagement can happen and where you can really articulate the many benefits associated with a project. Then once you've selected your project, you do that environmental assessment. And so, and I should also mention that in Canada, if the project is environmentally beneficial, like a transit or a bus lane, there's a really streamlined self-certification process as well, which certainly informed our thinking here on the bills that we worked on. And so you're right. In California, we start off with what's bad and not about what's possible and what is good. And I think that really colors a lot about whether or not we can get anything done.
Thank you. Before you get away, Commissioner Aruna, who's also part of the subcommittee on this issue, has a question.
So, and first of all, I want to thank you for your testimony and for the previous testifiers as well. It's really been an education for me listening to all of this. I'm thinking about another completely different part of the world, which is healthcare. And I'm thinking about hospitals in particular, right, that don't just serve a community. They can, in Northern California, and particularly in the Bay Area, I can't speak for Southern California because I don't live there, but the placement of hospitals and the fact that by 2030, hospitals have to meet a different standard regarding earthquake safety. And so and I'm just asking because I don't know the answer. Under CEQA, how do hospital reconstruction and things like that get impacted? I live in the community of Berkeley, and literally the history of the relationship between the city of Berkeley and the hospitals, or the hospital that is in our community, right, has been rife with neighborhood opposition, and now the neighborhood wants to save it, right, because they're fearful that there might not be a hospital close enough. Isn't it only typical of Berkeley? Now they want to save the hospital because it is the only hospital on the I-80 corridor, right, between Vallejo and Oakland, right? It's a pretty scary thing. But they need to reconstruct, right? It will not meet the 2030 standard. And when you think about this particular hospital and its location, how are they going to do that if they have to go through a CEQA process? And weighing here's weighing the positive versus possibly the negative, I don't know. But how does that work? And are hospitals covered under CEQA? Do they have to go through the same process? I'm presuming they are. And so I'm interested in your weighing thing.
Sure. So first off, I'm not a CEQA attorney or an attorney, period, just a public policy person. I also don't know anything about hospitals. But what I would imagine is that it would still, any physical change that they would make would need to be approved by, as a discretionary, permit by the local government, and therefore it would be subjected to CEQA. Now, maybe that's another area where something like anything a hospital might need to do to be resilient to future hazards is something that should be exempt. I don't know. This is not my domain, but that might be another class of issues to think about, is what are life-saving infrastructure that, is important to make sure you don't have catastrophic failure, and how we make those types of changes happen more quickly.
I mean, there's a plan. The problem here is we have competing planning processes, kind of, right? Not that the state has a plan for healthcare, because it doesn't, right? That would be helpful if it did. But there's a planning process, right, kind of regarding healthcare, and then there's CEQA, and then there's a general plan, and right. And the question is, how do they all integrate at some point? And is there a possibility that could ever happen?
I would hope so.
Yeah, don't, it's almost like if there's silence in the room, people feel the need to, fill it. But if you don't feel comfortable with that, and I think you've raised some good issues, and we've got two witnesses coming up. That's an associate professor in urban environmental planning, School of Architecture, and then another law professor from Berkeley. But let me express on behalf of the commission, thank you again for your testimony and what you bring to the table. Thank you.
Thank you for having me.
Thank you, Mr. Chairman. Our next two witnesses will testify remotely, and they will testify together, and then we'll take questions. I will introduce them both. Moira O'Neill is an associate professor in urban and environmental planning at the University of Virginia School of Architecture, and also an associate professor of law at the UVA School of Law. Professor O'Neill's research blends legal research with planning research methods and supports state and local government efforts to mitigate the impacts of climate change while also addressing inequality. For several years, she has led the comprehensive assessment of land use entitlements study, a collaborative study that joins legal and planning scholars to understand how land use regulations influence residential development patterns. She's a graduate of Golden Gate University and also Hastings College of the Law, or what was then Hastings College of the Law. Testifying with her will be Eric Biber. He is Edward Halbach Professor of Law at UC Berkeley. He teaches courses in property, public lands, and natural resources law, among many other topics. He helps lead the environmental law writing seminar and is director of the environmental and energy law programs at Berkeley. He was previously a litigator with Earthjustice and holds both master's and law degrees from Yale. So Professor O'Neill will begin, and then Professor Biber.
Thank you so much for the introductions. And since you've introduced me, I'm going to skip past introducing myself again. I am going to report out today findings from a study that Eric Biber and I launched in 2016 with other students and colleagues. And this study explores, if we go to the next slide, it actually explores how local governments in California apply their own law, local land use regulation, and state law, including the California Environmental Quality Act, to proposals to develop housing, whether that be residential development or mixed-use development, that would yield 5 or more units of housing if that housing were built. A lot of what
Professor O'Neill, this is Pedro Nava, and I'm just I'm looking at the room, and everybody is leaning forward in order to try to hear you. So if you can either speak a little louder or move the mic closer to you, I think we want the benefit of your testimony.
Absolutely. Can you hear me better now? Is that better?
Yeah, that is better.
Okay, you're going to see me leaning forward as well, so you'll see. So thank you. So our study explores how local land use regulation and how environmental law, the California Environmental Quality Act, applies to proposals to develop 5 units or more of housing, whether it's coming through a proposal to develop mixed use housing, mixed use, or residential development. Importantly, our study design has multiple steps. So if you go to the next slide, I will describe how we actually approach this work. So as a starting point, over the years, we have grown the scope of our research to now include 28 local governments or jurisdictions across California. So we have selected our jurisdictions carefully when we have chosen to study them. We have a mixture of large and small cities in high-cost regions throughout the state. And that includes 8 of the 10 largest cities within the state of California. We have both infill spaces and ex-urban development spaces within our study set. One of the first things we do in our work is legal research. So we explore very carefully and very thoroughly how these jurisdictions develop their planning and how they write their zoning. In other words, all of the different kinds of rules that they apply to proposals to develop land. And I'm going to discuss what we've found with respect to that. But some of what we do allows us to also use additional tools like planning research tools to understand zoning, in particular density in use controls. So for example, one of the questions we're really interested in is how many parcels or how much land area in any given jurisdiction is zoned for density. And when we're referring to that, we're really interested in what would allow for affordable development or development for all income levels as determined or set by state law. So for example, we use mapping and zoning shapefiles to calculate the amount of land area zoned for 30 dwelling units or more, as well as other multifamily development and single family only zoning, and then other uses that do not permit any residential use at all. We also want to understand how the law is applied within our jurisdictions. And here we build a data set, and that data set includes all approvals of development that would yield 5 or more units of housing if built over a period of time. Today, I'm going to emphasize our findings or discuss our findings for approvals issued in the years 2014, 15, 16, and 17. Our work is ongoing. We have been expanding the study years, but today for comparative analysis and to explore some of the questions in today's hearing, we're going to focus exclusively on those findings. In this work, we are very, very detailed in our coding. And so what that means is we pull out staff reports and motions and agendas and decisions that are issued by local governments. We also look carefully at how they apply CEQA or environmental review to proposals to develop housing. And that allows us to create a data set that yields information through descriptive statistics or spatial analysis, so we can answer a range of questions. And some of that I'll share with you today. And lastly, we complement our work with interviews with stakeholders in the process. So we interview affordable and market rate developers. We also interview people that work within local government, including planners. And we also interview community-based organizations that have an interest in development within these jurisdictions. If you could go to the next slide, please. One of the first things that's an important finding, one of our most important findings in our work, is that it is also, it's true that state law requires all jurisdictions to zone at least some land for all income levels and for multifamily housing, but we find that actually jurisdictions tend not to zone very much land for that kind of development. So what we found is that most of our jurisdictions that we've studied, and some of them are on this slide, zone less than 10% of their zoned land area for all income levels. So that's represented by the green bar. And you can see how that green bar gets smaller and smaller as it sort of goes down the slide. And that's important because when we talk to the developers, particularly affordable housing developers, they stated that Appropriately zoned land is one of the most important things to allow for affordable development. It is not the only thing required to provide affordable housing supply, but it is a necessary condition. If you could go to the next slide, please. This slide is a visual representation of what we mean when we say we conduct legal research. So we explore all of the procedural rules that attach to proposals to develop mixed-use development or residential development. And specifically, we're really interested in whether or not a jurisdiction allows for that development to move through what we call a ministerial process as opposed to a discretionary one. And that's really important for today's hearing because discretionary approval processes require CEQA. Ministerial processes do not. What this visual is telling us is that those cities that are listed with the underneath that line, that blank line without any sort of structure above it, do not allow for any proposed development to move through a ministerial process as their law is written. On the other side of the screen, you can see that there are some jurisdictions as the law is written that would allow for some apartment buildings, for example, to move through a ministerial approval process. If you could please go to the next slide. When we analyzed, however, how they applied the law through our data set, we discovered that even though several jurisdictions might provide for a ministerial process, very few actually had evidence of applying that process. We could only find evidence of ministerial approvals in the County of Los Angeles and the City of Los Angeles. If you could please go to the next slide. What that means is that the approval processes are both complex in terms of the requirements that they impose on developers under the local law. They also require CEQA, and that can take very, very long. So for example, the top of this chart, you see cities like San Francisco and Berkeley, Palo Alto, and San Jose. San Francisco having the most extreme timeframes in terms of length, but Berkeley comes right below it. And in this, we see that discretionary review can increase costs and increase difficulty for proposals to navigate all the way to construction. If you could please go to the next slide. We are in our data, for example, able to explore the types of environmental review pathways these projects actually move through. And we can tell you that very few developments that navigated their way through to approval actually required an EIR. That was very uncommon. It is more common that different jurisdictions will use other tools to satisfy environmental review. That can range from exemptions to what we call tiering or tiering off a prior environmental impact report or mitigated negative declarations or negative declarations. What we found though is considerable variability between jurisdictions that might use the same processes. So on this slide, we're comparing timeframes across jurisdictions that are using exemptions to satisfy environmental review for developments of 5 or 49 units for apartment buildings. And what we see here is that San Francisco's timeframe doesn't really change that much from its median, as illustrated on the prior slide, whereas it does in Berkeley. I would also note that in the context of the rare environmental impact report, there's a lot of variability there as well. San Francisco's median timeframe for an entitlement that required an environmental impact report would take 41 months, whereas in Oakland, it would take 10 months. So what we can say here is that there's considerable variability at the local level, that EIRs are uncommon, but that we see considerable differences between jurisdictions. We do want to note, however, some limitations of our study that are relevant. We do not study denials or, for example, proposals that are denied at some point. And we also do not explore the universe of potential projects that are never proposed. On the latter point, that's actually very difficult to study, and we've written and explained why we don't try to include that in our research, because we would be reliant on interviews to try to understand what never makes its way up to the proposal stage. And interviews are important, but they are also subject to bias because usually the interview participants are voluntary. I'm now going to pass it over to my colleague, Eric Biber, who's going to talk about community opposition in our data.
Professor, if you can wait just a moment, we have some technical problem.
Professor Biber? Hang on just a second. Yeah, you're coming across as though you swallowed helium, so give us a moment. Sorry.
Ashley. Ashley, if you have any suggestion about how to.
That might be an audio problem on his end. I'm not sure.
Yeah. I wonder, Professor O'Neill, is it possible that you might be able to describe or you can, or Professor Biber, you can try getting out of the meeting and coming back in.
I can describe what our data shares, and I think when Eric joins, maybe he can jump back in.
Okay, thank you.
Sure. One of the things we did in our research is we explored how frequently project opponents might oppose development approvals through either what we call local administrative appeals or through litigation. And that means whether they use the local process is available to them to object to an approval after the approval has been issued, and the rate in which that happened, and then how frequently people who opposed a proposed development's approval, once the approval is issued, would take that matter all the way to court. And I think one of the most important findings that Professor Biber can elaborate more on once he rejoins the Zoom is that we actually found a very low rate of litigation within the set of approvals that we studied.
I'm back. I'm back.
Great,
Is it
great.
working better now?
It is.
All right, perfect. Why don't I continue?
However, Professor, if I can just ask Ashley, if you can please make it so that we can see the professor as well on the screen.
Yeah, my video is on.
There we are. There we are. Now we can hear you normally.
All right, terrific. Thanks for your patience. So as Moira indicated, what we're able to do is take our data set of completed entitled projects and match them to circumstances both where there's been administrative appeals at the local level, which we can discuss if people are interested in, as well as litigation of any type, not just CEQA, challenging the project. And that has not been done before in the data collection that's been done out there. We have found a litigation rate of about 3% of the over 2,000 approvals in our data set. That's about 7% of units entitled. Litigation rates are higher in Southern California than in the rest of the state. Among the claims raised in those lawsuits, the vast majority have a CEQA claim, but about 2/3 or over 2/3 have other legal claims, usually claims violating local land use and planning rules as well. So those are lawsuits that would potentially proceed even if there were not CEQA claims involved. In terms of outcomes, the vast plaintiffs or petitioners rarely win on the merits. More than half the cases settle, and then most of the rest of the cases that are decided on the merits, the defendant wins. There are extensive delays for projects that are in litigation, particularly when the case is appealed up to the trial, up from the trial court to the Court of Appeal. So that's an overview of our data. I can also provide a brief discussion of some sort of overall proposal we have for improvement here. As Moira was present, yeah.
Can I just ask a quick question? Did you, in your data analysis here, did you isolate out the size of the project? So is there more litigation for something that's 100 units versus, 5 units? And if the larger the project is, does the percentage go up? Just curious.
Yeah, so you can tell from my numbers that there is going to, there's a higher rate on units than on number of projects. So on average, the larger projects will probably be a little more likely to be litigated. That being said, the biggest factor we found for whether a project was litigated or not, when you looked across CEQA timeframes, was whether there was an EIR or not. If there isn't an EIR, litigation rates are quite low. If there is an EIR, the litigation rates are much higher, up to about over 20% per project. So
that's so interesting, because if there's an EIR, the standard for review is actually more stringent. So it seems to me that there might be something else going on.
Yes,
I agree. Because those should not correlate the way it just thinking out loud, it doesn't seem like that's the proper correlation.
No, I think what's going on is underlying political pressure. And I think that's as I was saying, that's consistent with what my colleague has presented as well. So what we see is CEQA litigation as a downstream effect of political contentiousness over projects at the local level, such that these are projects that they're pushed to EIRs because there's dispute over the project within the community. I also, I didn't mention administrative appeal rates. Those are internal appeals pursuant to a local government's land use regulatory system. Those rates are much higher than litigation. 11% of projects, over 20% of units are administratively appealed. And again, you can also see how this all follows downstream from the land use regulatory system that the local government adopts. If you make it discretionary because you're responding to local pressure about whether you're going to approve projects, then that will trigger CEQA, which in turn will trigger opportunities for neighbors to use the process to object to the project. And if they don't like the project, then it'll continue on pushing for the EIR and then pushing for litigation. So sort of what we have focused on in our work is really focusing on local land use control as a key driver for the difficulty of housing production in California, and working on efforts to improve that process to facilitate more housing production and particularly affordable housing production in the state. And I think we don't believe that if you just do changes to CEQA without addressing the underlying land use regulatory system, that you're really going to move the dial a lot on housing production in the state. That being said, we also agree that CEQA reform would be beneficial in this context as well. And our primary proposal is to streamline CEQA review within core urban areas to facilitate infill residential development by designating infill priority areas. In those areas, residential development proposals and mixed-use development proposals that are primarily residential would generally be exempt from CEQA review. The same exemption would also apply to local rezoning decisions that raise the capacity for housing in the production in the jurisdiction. And this has, I think, we think three primary benefits compared to current law. So first, there's a lot of CEQA exemptions currently applying to residential projects, but they're quite complicated. They have a lot of exceptions to the exemptions. The exceptions to the exemptions sometimes are not clear as to how they apply. That can increase uncertainty and cost for project proponents. Secondly, most of those exemptions apply to individual projects rather than to rezoning, which is going to be a critical issue, as one of the commissioners noted earlier, as local jurisdictions respond to the need to produce more housing to meet their RENA requirements. And then lastly, and Professor Elmendorf mentioned this earlier today, local governments' decisions to not apply a CEQA exemption are not reviewable in court. And that creates a real imbalance in the legal pressure as well as political pressure that local governments may face to apply CEQA or not to a project. And that also means that local governments that wish to strategically use CEQA to evade state housing law, like the Housing Accountability Act, are able to do so without recourse for project proponents. So our proposals are threefold to address those. One, a mapping system for these infill priority areas that would make the process of deciding which projects fall within the categories much easier to understand, using the mapping process to exclude areas with important natural resources and environmental resources like wetlands or endangered species habitat, and also areas that would not, that would result in an increase in vehicle miles traveled to help advance the state's climate goals. Secondly, we'd set a high bar for exceptions from the exception, and I can cover that in more detail if commissioners are interested in. And then lastly, a possibility of outside enforcement of local government decisions not to apply the exception, maybe judicial, maybe administrative, and allowing that for project proponents, but also the state AG's office and other interested parties to facilitate a more equitable application of CEQA for projects in this context.
Commissioner Biber.
Well, thank you for the testimony. It's sort of amazing stuff. And rarely do we get to hear such eloquent proponents of academic research explain things in a cogent way. So thank you. I guess I have a kind of first higher altitude question, which is we can solve or seek to solve CEQA problems for housing, or we can seek to solve CEQA problems across the board. And one of the earlier witnesses in the first panel suggested that one of the things we could look at, which your work actually kind of underlines, is legislative activity changing the practices of local governments with respect to housing. And that's kind of the focus that you guys have. What I'm wondering is whether you could extrapolate from your work the unintended consequences or the adverse consequences of CEQA as applied outside housing. Because it seems like there's some themes about the use of CEQA, whether it's housing or other practices, and whether you have any insights on that. It's kind of, okay, if CEQA is a infrastructure like a house, you know, we know there's some bad things going on in the housing market, but there are also problems in other rooms of that same house. So do you have experience beyond housing?
Sure. Moira, do you want, or do you? Yeah, so I think a theme, and we're doing ongoing work in the cannabis cultivation context, understanding local regulation in CEQA as well. So I think there's a couple systematic issues that I think are at play, but again, consistent with our work, I think these are issues that are in some ways more fundamental and broader than CEQA, that CEQA is downstream of these issues. So on the one hand, in the context of housing, I think you see an example of the challenge that local governments may be particularly focused on the local negative impacts of a housing development project without necessarily taking into account the regional or statewide benefits of that project. And that's a systematic issue that's going to turn up both in how local governments regulate and approve those projects through their own processes, as well as how they'll apply CEQA. So again, I think our theme would be that looking at and trying to improve CEQA is an important part of that process, but it's probably actually not the most important part. And so if you think about it in the context of infrastructure, right, you talked about electricity transmission lines or large-scale transit projects that are multi-jurisdictional. That's an issue where, again, local jurisdictional decision-making may not necessarily produce what you want at the statewide level. And I think that, unfortunately, I know that means it takes you outside of the particular focus of what you're looking at here, but I do think it's important to keep that broader context in mind as you think of what you want to do about CEQA. And then on the other hand, I think there's a complexity problem here in the terms of the complexity of state law. And this is, and local law, and this is something that's coming up at least tentatively in our cannabis research. And again, CEQA is only part of this process. You have a lot of overlapping state agencies and state regulatory programs intersecting with local regulatory programs that make it very hard for local governments, state agencies, and applicants to understand what they're doing and how it interacts. And again, you could try to work through that simply through CEQA reform. I think you're only going to get at a part of the problem. And that's why you saw our proposal. It's a proposal that I think makes sense in the context of other legislative efforts that have been happening over the past several years to facilitate housing production through efforts to provide some guidance and structure to local regulatory decision-making, statutes like SB 35, SB 8, SB 10, and other legislation. Our proposal is one that sort of works with those. It facilitates local governments when they want to do development. It makes it easier for them to do CEQA, and it also means CEQA is no longer a tool. It's not as easy a tool for local government to use to stop a project if they want to, if the project would otherwise comply with local government rules. But you see that necessarily requires you to think about how it intersects with the broader context. And I know that's makes it harder to do the reform proposals, but I do think this is why you keep getting people saying, well, let's think about the particular context in which CEQA interacts, because CEQA necessarily interacts with the state and local law at issue, right? The ministerial discretionary provision is a critical part of that, as well as the fact CEQA often incorporates the relevant state or local regulatory standards for standards of significance. And that means that CEQA reform in one context or changes to CEQA in one context can have very different impacts in another context. I hope that was helpful.
Yeah, maybe an observation and then a question. The observation is we have some goals, climate change goals, let's say, and they seem to come into conflict with procedural isms. And there's a law professor you probably know, Nicholas Berkeley, who writes about law as a fetish. That is that the procedure has contradicted the underlying social policy goal. And do you think we're at a stage in California where we're not balancing the desired outcome from a climate or housing change with the procedural protections, and that we've sort of elevated process over substance?
Go ahead, Moira, if you had thoughts. Or
Sure, I can offer thoughts. I think actually we can also speak to some additional extensions of our research and use of our data that somewhat tap into this question. I think that's an extraordinarily complex issue to try to offer sort of a summary opinion, because I think the importance of process is always context specific. So one of the things that we've observed in our data and what we're able to do is how things can move through process, or how process can change as a consequence of state intervention and local process that considers a variety of contexts and various, tries to balance different policy goals. So I think the point that you're getting to in terms of the complexity of trying to advance, outcomes that would be consistent with what our goals are to address climate, but also thinking about housing production, actually kind of comes through in some of what we're exploring in our data as to the application of Senate Bill 35. So we have the benefit of being able to see within our study jurisdictions how Senate Bill 35 operated to transform process for proposed, dense affordable development or mixed income development that met the state law's requirements. But what's important about that is it doesn't actually eliminate all process. It doesn't do anything to disrupt the local government and the local community's decisions about where dense development should go within the boundaries of its community, within the boundary of the community. And it also still requires consideration of a variety of important elements that process is meant to attend to, right? So you're not able to proceed through a ministerial pathway that relieves you of environmental review if your parcel, doesn't meet certain requirements with respect to environmental conditions or sensitive lands. And there are consultation requirements with respect to indigenous tribes and populations and so on. So there's a lot of different elements that process is meant to attend to, incorporated into the structure of offering this state required ministerial pathway. So there appears to be a balancing happening between trying to advance a certain outcome. And what we have seen in our data and what we're releasing soon, and it's, we've got the findings already completed, is that there has been an improvement in terms of the outcomes, but the balancing isn't eliminating all procedure. It's just being mindful of where there might be sort of, for lack of a better way of saying, overkill. In other words, you've gone through all of the process to identify where you want to have dense affordability and so on. And you've thought through all of your design and aesthetic requirements as a community, and you've thought through all of those things. So once you've completed all of that, now the proposal to develop is completely in line with all of those procedural steps, but doesn't now need to go through an extra layer of process, but can move through an expedited pathway.
And if I could also sort of generalize out of that, I think to the question of whether you want more or less procedure is going to depend on the policy goals you're trying to pursue. And again, this is why you're getting sort of these frustrating answers from people. Well, it depends on because CEQA applies across the entire state government, it probably depends on the particular policy goals the state government and its entities, local governments, are trying to pursue in a particular context. And I think that's why you're going to probably want to think about, okay, what are we trying to accomplish with this law and as a state, and then understand how you want to adjust CEQA when you're trying to accomplish those goals. And I think one of the reasons we work through our proposal of these priority areas is these are areas where I think you can have a strong presumption that dense residential development will be beneficial environmentally as well as economically. And you can flip the burden on CEQA such that you can make it much easier to go through the CEQA process or do no CEQA process at all. And this sort of gets to the questions you had earlier about balancing costs and benefits of projects. I'm really wary of a generalized, hey, let's put balance benefits and costs into when we do CEQA as a general matter, because I think you're just going to make the CEQA process even more complicated if you do that, because there's all sorts of benefits that might come up. It's often hard to document or quantify them. I do think it's a a better approach is there will be areas in which, as a state, we feel very comfortable that certain kinds of projects or activities that state and local governments are doing, we can presume the benefits of them from an environmental perspective outweigh the costs of them environmentally. And unless we have a lot of evidence to the contrary, there's not a role for CEQA to play in that context. And I think that's going to be a much more effective way to deal with this issue as a general matter.
Great, thank you. It looks like there's a commissioner interest. I would remind commissioners, you got about 2 minutes here because you're going to want a bio break before we do the business meeting.
No, I'll be very quick, but I'm going to give an example and then I'm quite curious about your views, and it builds on Commissioner Byer's question about housing versus the overall CEQA. Obviously, climate change is not just a problem for California. It is a worldwide problem. And so, for example, I think we can point to the Tesla factory, which made a decision to build outside of California, but almost right on the state line to not deal with CEQA. But we in California are living with those climate change problems. The good jobs are very important to California. Those jobs are in Nevada. So where is, and again, the climate change, the California laws are important, but we need to have good governance to make sure that people, they can't just cross the line and do what they want. Is there a process, not just for housing, but in CEQA in general, not to make it so burdensome, the process, so that you don't see a situation like that where we're all suffering now still for the environmental impacts, but there was no recourse because they did it over the line? What is there a response to that?
Yeah, I mean, I think the Tesla case is somewhat different. I would be curious to know if we thought that there were significant environmental benefits to having that project in California as opposed to Nevada, right? That's the difference from the housing context, where you can make arguments about vehicle miles traveled, as well as impacts on other environmental resources in the state, that it's much better to place that housing in urban infill areas than in other areas of the state. And I don't know the specifics. There may well be good arguments that would have been the case, that it's better to have the Tesla plant, say, in Fremont, co-located with the assembly facility as opposed to Nevada. But that's the way I
would just say California has stronger environmental requirements than Nevada. So having it here, we'd probably have a cleaner project, but just part of the discussion.
Perhaps. I mean, it depends on the project, and you can make those arguments in general, right? And then at some point, you don't do any regulation at all up front because you're right. So I think that's the way I would think about it. I think the challenge is trying to create a system where you think about it that way, that you don't make the process worse. And that's the real concern. That's the thing, the challenge I think that faces you. I think it's not an easy challenge to resolve. That's one of the reasons this has been a difficult topic it's been a difficult issue to do the kind of legislative fixes people have talked about.
Okay, very good. I want to thank you for your testimony. I think it's going to be very helpful to the commissioners and staff as we formulate recommendations looking at CEQA. I think points that have been raised by the witnesses are to be strategic with respect to those areas that you want to examine. Exemptions are an avenue, but they also have to be handled carefully, and that any thought of a wholesale rewriting of CEQA is a fool's errand. You didn't say that, I just did.
Yeah, I wouldn't go quite that far. I do think I'd be happy to talk with staff. We'd be happy to talk with staff some possible tweaks on litigation context as well. We didn't have time to get into that. We could happily follow up with staff on that.
Thank you so very much. So that is going to conclude this morning session. Let's take a 5-minute bio break to return for the business meeting, and we'll start that as close to 12 noon as we can. Thank you. It's time for us to start the afternoon session of the Little Hoover Commission on the effects of the California Environmental Quality Act. This is part one. Let me turn this over now to Executive Director Ethan Rarick.
Thank you very much, Mr. Chairman. So the first witness this afternoon, who I will ask to come up now, is Dan Dunmoyer. Dan is the president and CEO of the California Building Industry Association, where he oversees all aspects of the association, which represents home builders. Prior to joining the CBIA, Mr. Dunmoyer had various legislative caucus staff, leadership and policy committee roles in the state assembly, starting as a Jess Unruh fellowship, fellow. He was president and CEO of the Personal Insurance Federation of California from 1996 to 2005. He was also later deputy chief of staff and cabinet secretary for Governor Arnold Schwarzenegger. And most recently after that, served as senior vice president and head of government affairs for both Zurich and Farmers Insurance companies. Thank you, Dan, for being here. Please go ahead.
Thank you, Mr. Rarick. The only thing I would add, just so you understand who the California Building Industry Association is, about 8.5 to 9 out of every housing unit built in California is built by one of our members. And we build all types of housing, which includes charity, legally defined affordable, middle-class housing, and luxury housing. I'd say about 80% of what we build is either middle-class housing or middle-class rental housing. So kind of think of school teacher, firefighter, income levels. That's the focus of about 80% of the units we build. Either you're renting or you're owning. But we do all the above. And the reason why I mentioned that is CEQA touches all the above. So let me just,
can I ask you a quick question on that? Just because this goes along with some comment I made earlier. What's the range of sizes of the builders that are part of the BIA?
Glad to answer that. We represent all sizes. We represent people who build as few as 4 homes a year. And the largest home builder we represent is Lennar, largest home builder in America, builds about 9,800 homes a year in California alone. The primary membership of our board is small to mid-sized private builders. Think Harry Elliott for those of you who live in town, DeNova if you live in East Bay. And then we also have on our board the large builders. So that's kind of the scope of our buildership. I'd be remiss if I didn't recognize Mr. Nava. Thank you for your leadership here. And I also have to call out because I'm so much happier sitting in this chair than the one I normally do. But my dentist from Hemet is on your commission with Dr. Emerson. So I learned a lot from him. You never get to talk when you're in the chair. You just get to listen. So this is my chance to get back at him. But good to see you, Dr. Emerson. Always a pleasure. So. Yes, so our builders, like KB Homes is a California builder who builds nationally. So when you look at a Lennar is located in Miami, but has a massive headquarter in Irvine. But we have builders that are, we call national publics, which in English means they're on the New York Stock Exchange, and they build in anywhere from 8 to 22 states. So we represent both the largest builders, and we also represent people who will do custom homes for 2 people. So with the lion's share of our income comes from the larger builders who build, they all build in California, but they build nationally. And I'd say 2/3 of those, well, it's a higher number as of last week. We just lost Landsea Homes located in Southern California. They moved out of state. Many of our builders were originally in California, but most have moved their headquarters out of the state over the last decade. But they still build a tremendous number of homes, tens of thousands.
You don't need to provide this now, but I'd love to know diversity numbers as well of your membership at some point.
You mean demographic, ethnic? Mm-hmm. So it's primarily, some of your questions this morning were amazing. I know I'm jumping all over here, but because of CEQA and things like CEQA, it is a market closure dynamic for our industry. We have one woman CEO in the top 20 builders, Cheryl Palmer with Taylor Morrison. The rest are men. As far as the rest of it, we are bringing a lot more women. We have won national awards as CBI, bringing in more women than any other association in America. But even that being said, it's abysmally small. Diversity of color, my staff's 80% diverse. The industry is about 95% Caucasian, white. A lot of that, in my opinion, and I think the facts bear it out, is when you're going to wait 20 years, one of you mentioned this morning, it's hard to tell who's all speaking, watching remotely, but when you have a 20-year tail to build in California, it's just old money and established money that can survive that, or Wall Street money. And that tends to be primarily male and Caucasian. And I can get away with saying that because I fit that demographic. So that's, that is the reality of what happens with delay and complexity, whether that's CEQA or permitting, et cetera. So.
Yeah, I have a question, sort of along the lines I think that was raised by other commissioners earlier. And it's around, I'll call it economic demographics or economic diversity. If as a result of a thing, CEQA is a thing, it requires a high amount of capital, and that tends to concentrate the market in terms of market share, antitrust purposes, but also has an effect on diversity, equity, and inclusion. Leaving aside the cause, what's the hurdle to entry in home building? And in other words, are women-owned businesses or minority-owned businesses, do they have a prospect of entering the market given the complexity of the regulatory environment? In other words, how much capital would you need to get into home building, even if it was 4 or 5 homes? And that's sort of a general question.
So if you're doing custom, matter of fact, women do very well in the small space. They have an amazing eye. My mother was this woman. She had, women she would contend that she sees a home in a different eye than a man. That could be sexist, but that's my mother, so she can say it. But if you're building 4 or 5 homes, there's really no barrier to entry because you won't build a home until somebody gives you the money. And that lot's already finished, and you won't build it if there's still CEQA. And a neighbor can do neighbor-to-neighbor CEQA. But you wouldn't, as a small builder, you'll just wait until you can actually build, have the permit and build. So the risk is minimal. So the size and scope, there's a lot more demographic dynamic and engagement of women in the small marketplace. Outside of California, there's a lot of women in building. So it's not an issue. We have a joke in these other states like Florida or Texas or Tennessee or Idaho. If you've got a truck and a hammer, you're a builder because you don't have to pull permits. You don't have to have financing. You go to a local bank and you build. But in California, that's the dynamic. Outside of California, the chairwoman of the National Association of Home Builders is a chairwoman. She's a woman. She builds 11 to 15 homes a year in Georgia. Has no problems doing that. California, you can only do that if people pay you up front and have the lot ready to build, because you're not going to wait. If I came to you and say, hey, I want you to build my house in 20 years, I'll pay you. You just move on. But that doesn't happen on custom. That happens on larger developments. So, Mr. Chairman, just some opening comments, and I love this dialogue, so I'll try to be brief so we can have more dialogue. So what I'm contending today, and we're talking about CEQA, and you heard some great professors this morning. Spur did a great job. I had to pop out at that point, so I didn't hear the rest of the panel speakers, but this is a component of our challenge. So I've been asked to speak on CEQA, so I'll explain that from the context of a home builder, which is the lens I'll give. You're going to hear from, I believe, the preeminent lawyer in California, representing trying to get to yes on CEQA, Jennifer Hernandez. So you'll hear from that expertise. And I'm not a lawyer, and I no longer play one on TV, as I used to say when I testified in the legislature. So I'll focus on the home builder perspective of this law. I also want to contend, because I do think the speakers this morning raised some good points about be careful about the statistics you hear, because statistics can be used or abused in any way you want. I'm not going to give you CEQA statistics right now. I'll just give you pure facts. This is totally verifiable by the Department of Finance, Housing and Community Development, and by an organization called CURB, which is a research bureau that just tracks permits pulled. So these are real stats. I'll take CEQA out of the equation. But according to our governor, the former governor, and the former governor before that, each one of their housing and community development departments said we need to build 180,000 homes a year to keep up with our housing need. And as recently as about 6 months ago, the head of HCD had the same number. So it's a pretty standard number, even with some population movement outside the state, 39+ million Californians. That's just the status quo. Either homes atrophy, fall apart, fires, whatever it might be. So the real numbers are since 2008. So in 2009, we built 35,000 homes in California. Our best year since the Great Recession was this past year. It's not official yet, but unofficially the numbers are around 128,000. So we are not anywhere near building the housing units we want. CEQA does play a big part of that, not all of it, and I'll contend that. But to me, I just look at, the numbers. If somebody says, well, you can't believe all the CEQA numbers. You can't believe these numbers because these numbers come from the cities. All 500 jurisdictions, 464 jurisdictions provide this to this organization called Curve Monthly. And that's what we track. That's the true number. So when you read the press releases, and we support most of these bills, by the way, that have positive press releases about adding housing units, SB 9 last year that would change Western civilization. God bless Senator Atkins for taking this on. Pulled about 100 permits last year. So it's a good bill. It's the right bill. It brings more housing units in. But if you read all the press releases on the housing units that would be developed from all the laws passed, I'm not picking on these lawmakers. They're trying to move the needle. It would be somewhere in the neighborhood of 6 million homes would have been built in the last 5 years. Well, in the last 5 years, we've built about 400,000 homes. And I realize, I used to be a staffer. I know how to write those press releases. But the point is, the real numbers are we're not building. The other real number you should know about is before CEQA, back in the dark ages when I was a toddler in Hemet, we could pull somewhere in the neighborhood of 300 to 330,000 permits a year. When we had more than half less, about 14 million people, we were pulling 330,000 permits. Now we have 39 million and change, and we're pulling 120,000 permits. That's single family, multifamily, affordable, charity. It's all the permits. You have to have a permit to build in California. So those are the real numbers. They're outside of CEQA for the discussion. That includes homes that went through the CEQA challenge, homes that avoided the CEQA challenge. But that's the real math of where we are as home building and rental building in California.
So when you pull a permit, do you pull one permit for 100 units and one permit for 1 unit? Okay. So the actual number, you could have pulled that many permits and then each one could be a huge development. So the actual number of units.
They're units. So if you have 100 homes, it's 100 permits. If you have 1 home, it's 1. So it's those are each unit has a permit.
So an apartment building with one building, 25 units.
25 permits.
That's 25 permits. Oh, okay, great. Thank you for clarifying that.
So a few things just to be aware of on the context of CEQA. We contend that CEQA most often is not used as a tool to protect the environment. It is obviously the California Environmental Quality Act, but it's oftentimes used, as one of the commissioners said today, to bring you to the table for a negotiation with labor, bring you to the table to negotiate with the neighbor. It is often used as a competitive way. We see this a lot with hotels. I don't want a hotel near me. We see this with restaurants. So it's a market closure tool. It's a delay tool. It is used for environmental purposes, but many times, most times, we would contend as builders, we don't modify a lot of what we do for the environment. We modify a lot of what we do for the interest who's brought the potential challenge. It doesn't even have to be a lawsuit. It's just, hey, I'm thinking of doing this thing called CEQA to you. You should probably talk to me. I think the other thing just to keep in mind as we look at some of these key issues is how easy it is to use CEQA. You don't have to hire the best law firm. You don't have to have a lot of money. Any neighbor can do this to a neighbor, anybody. We see CEQA being pulled by out-of-state parties on in-state California activities purely because it has an extortive value, and you can get people to the table to effectively legally pay you off just to try to get your project to go back. So let me talk about this through the eyes of a builder.
Sorry, question about that. It's not unusual for venture capital firms to fund litigation. Is there an example that you're trying to point to from out-of-state funding, which sounds, of course, scary, of financial interests essentially arbitraging CEQA and making money from the arbitrage?
I mean, you see that more.
So you're saying something, use it in a competitive sense. You've got a hotel, you don't want the next hotel. Somebody comes in, finances the CEQA reform to either delay or prevent the other hotel. Somebody makes money on that. And is there a syndication function within the CEQA abuse you're describing?
You don't see it the same way you would in traditional plaintiffs' lawsuits where people can effectively invest into a lawsuit. You don't need that much money. You don't need, 5 of us putting in $250 could take care of this. So if you're talking about a complex litigation, this isn't that it's very complicated once you get into it. It's not complicated to start the process. And that's, you don't need investors. I could do it with a $10,000 bank account and do a lot of it. I could stop what's happening in the Capitol with hardly any money. So let's look at this through the lens of a builder. So when CEQA was first enacted, I talked to some of our quote old timers, and they would talk about walking into a permit process, and they would pull a 1 or 2 page document and they would complete it, and that was CEQA. Right? This is in the first 10 to 12 years of its existence. Now you'll hear from my colleague, and she does get paid by the word, but she has to issue a lot of words. It's not uncommon for CEQA documents to be in hundreds and thousands of pages. And so that whole process has gone from a 2-page document to a 1,000-page document. When I talked to a couple builders, I said, so, when you're going to do, you're going to walk into CEQA, either the local government is or community groups are, what's the normal budget you just set aside for that? And for these are mid-sized privates. So they build maybe 200-300 homes a year. They effectively will say, we roughly budget about $1 million. And so that's just what we kind of set aside to do this. That's not assuming litigation. That's not assuming a contracted long-term process. This is kind of an easy CEQA. And that, if it runs smoothly and everything goes well, is a 2 to 3 year process. But that's because CEQA really wasn't effectively utilized or fully utilized. So a couple other things just to keep in mind. For those of you that live in Sacramento, and for those of you who flew in today, when you head out to the airport, you'll see this thing called the Rail Yard Project. I worked on that with Governor Schwarzenegger. He was tired of driving by it on his way out to his jet. And he used to tell me, I don't like that eyesore, get that fixed. Get it fixed now. So we went around and asked for investors. And we got some investors out of Texas. The 2 investors before the Texans, Californians, went bankrupt on the project. So they came forward with a solution. And the governor's own administration didn't like it. I'll say that again, the governor's own administration didn't like it. Parks Department didn't like it. They wanted the Texans to build 2 more railroad museums. So they instituted CEQA. Now the Texans came back and said, we'll build 1 railroad museum. And you can see who won that battle. It's still vacant land. Walking distance to the Capitol, walking distance to everything, close to intermodal transportation, infill, high density. It is the perfect housing project that everybody wants us to build in California. It's still vacant land. There's no gentrification other than for dirt. So that gives you an example of just one-off. So when I talk to builders, they're like, that's kind of the lens that many builders, we have another joke, it's joke tongue in cheek. It takes 3 bankruptcies through CEQA to get to the completed project. And if you're really shrewd development investor, you follow those bankruptcies and you pick those up and eventually you build. So a couple of last things I'll say, and I'd love to get your questions. So when we look at CEQA, it's oftentimes presented to you as, look, Dan, you represent builders who do urban infill. We do urban infill. But you also represent builders who build in the suburbs, greenfield. And there's a sense in the current lexicon of public policy that that's not good for California. There's various reasons: fires, commute, vehicle miles traveled, another CEQA tool. So let's do urban infill. Urban infill is by far the hardest projects to get to yes, either by permitting, by local city governments, and by CEQA. The easier projects, not easy, but easier projects are suburban. Cows don't litigate as often as neighbors do. The other component that we see in this context of CEQA is this whole statement, well, Dan, if you quit doing sprawl, we could solve our climate problems, reduce our vehicle miles traveled, another CEQA tool, reduce greenhouse gas, get people into transit, which may not exist, but we'll get them into it, and we will solve this problem. 2 things you need to be aware of by that narrative. When you build urban infill, it costs so much more. If you go above 4 stories, it costs 5 to 7 times more. So when you tell people we want high buildings, tall buildings next to transit and stop this greenfield stuff, what you may not be aware of is what you're saying is we want housing for rich people and rich people only. You correct me and say, no, Dan, we can force you to build 10% affordable on each one of those projects. So then you're saying that other 90% is for really rich people, because every 10% of inclusionary is another $100,000 per door in expense. And that's why you see 2-bedroom, 1-bath, 1,200 square foot apartments in San Francisco going for $2 million. Nothing wrong with that. I'd love to have one of those, but that's not attainable housing for 97% of our citizens. The other thing just to be aware of on the sprawl stuff when we talk about CEQA, according to CARB, California Air Resources Board, only less than 7% of California's land mass, it's a big state, less than 7% has a brick, stick, cement, asphalt on it. So when you talk about sprawl, 50% is owned by Mr. Biden or Mr. Trump, depending who the president is. About 22% is owned by Mr. Newsom, Mr. Brown. Those are all state and federal owned lands. We only need 2% of the land mass, even if we sprawl, in quotations, to meet our housing needs of 3.5 million homes. If you pick Mr. Newsom's biggest number, he's down to 2.5. We'll take 2.5. We'll take 1 million. We'll take 250,000. We'll take any number. But the reality of the fact is we need 2% of the land mass. We can conserve 92% either through parks or farms and still meet our housing needs. So when we talk about using CEQA to stop sprawl, we're talking about 1 or 2% of our land mass if we build these communities. Last thing I'll say, when we look at this whole process, again, I haven't got into the long-term CEQA. We've got CEQA projects that Jennifer's representative have been going on since I was in high school, 1981, 82. A 30-year process is very profound. A few thoughts on how we fix this problem. I'll go through these quickly. Whoever files a CEQA lawsuit must disclose who the payer is. There's a Glazer bill on that. There's a Roger Needle bill on that. If the plaintiff loses the lawsuit, he or she or they pay. All government parties, preferably state, local, and federal, would pursue CEQA simultaneously. Fish and Wildlife does it. Department of Water Resources does it. CARB does it. That's just California. You just go through this drumbeat. And of course, then the locals do it. County does it. The federal government does it. Army Corps of Engineers then does it. The U.S. Federal Wildlife does it. So at least the government, especially if they're in the same party. I mean, we had Obama suing Jerry Brown. I mean, that's just wrong. I get Trump and Newsom. I get that. I don't get Obama and Brown. They're two peas in a pod, but they sue each other over CEQA. And so that to us as government should come together, but above all, each administration should be able to come together on that. Next item, when you do CEQA, do it once. You can do CEQA so long you can change the environmental impact with climate change. In 23 years, it's not an uncommon date for a project. Species can change. Flora and fauna can change.
Can I ask, can you clarify? So you do not want to see CARB and the Department of Natural Resources and the AG all separately named? Is that it? You want one person
sequentially. I don't want them sequentially. So CARB, the AG is the lawyer for the governor.
Right.
He or she should be able to sit, the state government should come together, have a meeting and say they're going to build this rail yard project. Does anybody have a CEQA concern? Well, Fish and Wildlife does, or Natural Resources does, or Parks and Recs does. They would all sit in a room and say, okay, let's all bring our issues together. Simultaneously, not sequentially, not like, okay, you're done 2 years, 3 years later. Now you
but
go.
Wouldn't the statute of limitations have run based on the document? How are you saying that this is sequential? I mean, at some point, if you're not in the game, you're out of the game.
No, you're never out of the game. New approvals, new issues.
Approvals. Okay, I see. So you've started a new statute of limitations. Okay. I wasn't understanding what you were saying. Okay. Thank you.
Last thing I would just say, and this is a touchy.
Let me ask a clarifying question.
Yes, Commissioner.
And so I'm familiar with a local project in Vacaville, which involved a challenged species, fairy shrimp. They grow in vernal pools. You might call them puddles. You might call them swamps, somewhere in between. And you've got a situation where paving over the land might be a fish and wildlife thing. And it makes sense for them to have a point of view. But then later, there might be a different permit from a different agency. So I don't understand how you could force the agencies in a timely way to have a point of view about CEQA, given that the phasing of the project. I mean, I like the idea, but it doesn't seem feasible.
The only thing I would say in that is when you present a project to government, I mean, you go from ideation to conclusion. You will show all the changes you're going to make to topographical, and everybody has access to that. So we aren't going to change it without permission. We're not going to change where we locate. If we move a stream, if there is even a stream, it could be just a puddle. Under waters of the state, it could be a tire track. So everybody could look at that document simultaneously and go through with their lens, whatever their lens is, air quality, transportation, species, and they could effectively then say, well, I'm going to add this to my list, and they would do it together. And, we do this when we have disasters. When Governor Wilson rebuilt the Santa Monica Freeway, you just do that in 82 days instead of what's happening here on Interstate 80, which is still going on. Last thing I would just say, and this is sensitive, but it's reality. The elephant in the room is how this is used as a tool on labor. So the dynamic is any of the reform bills require either prevailing wage or skilled and trained. Whether you think that's a good idea or not, it does add cost. We say it adds approximately 30% to the project of the vertical construction. What that means in English is we already use skilled and trained and prevailing for horizontal, which is asphalt, cement, sewers. That's all done by prevailing wage. What we don't always use in California and in every other state is certified union labor for what is above ground. And so when you're required to do that, and let's say you accept that as a good public policy, it still adds 25 to 30%, not of the labor costs, but of the project costs. And that's pretty easy to prove that because we build projects with and without a skilled and trained or project labor agreements next to each other. And we can show you that differential. You may say, Dan, that's a good thing to do because labor is so important and people should be able to afford to live in the houses they build. I would just contend that they can't because the cost is too high for most laborers. It's certainly too high for most school teachers, firefighters, teachers association unions, SEIU. I mean, they have sat down with us and said, we can't afford to pay for union individuals can't afford to pay for union built homes because they cost too much. So there's an irony there. SEIU is all up in arms with me. Like, why are you conceding anything to labor, building trade labor? Because we can't afford to buy those homes. So there are costs associated. Some, right now the legislature feels that's appropriate public policy. All I'm saying is there's cost to it. And my comments here.
Mr. Dunmoyer, on that point, is there a target on the size of a project that they look for in project labor agreements?
I wouldn't say there's a hard and fast number. They don't deal with small custom. But generally speaking, projects that are more than a couple hundred units is where you'll see labor at least considering it. Certainly the big master plan communities, which for us are the best environmentally sensitive and friendly communities because you can walk to work, school, church, job, et cetera, restaurants. That's where you'll see labor engaged with public project labor agreements. So they do look for the bigger projects. Generally speaking, they don't do the smaller projects. Other questions, comments, criticisms?
Yeah, I want to give you a little bit of a hard time about rail yard only because the history of that land is a bunch of toxic waste, as I understand it. So take a step back and imagine it was not located exactly where it is, but sort of generically, and you think about Bayview and San Francisco or some other disadvantaged community. CEQA has been essential for purposes of securing not just environmental justice, but racial or equitable justice. And so I just want to clarify, you're not suggesting that we eliminate CEQA or substantially undermine its effectiveness in securing economic justice. You're talking about making modest changes in order to facilitate the other large social policy goal of building housing.
That's correct. And we do it for stadiums. We do it for large projects. We do it for billionaires. I'm just saying we do it for the middle class. No, you have to clean up the rail yard. You can't build on brownfield, but you can build on cleaned up brownfield. And if you don't add too much cost to it, it will pencil. You can actually clean it up in a manner that is acceptable. And, if you don't have to wait for 30 years to do it, you can actually pencil it out so you could build it. That's the point. This is California. We're not going to get rid of CEQA. The question is, can we work with it in a manner that allows us to build middle-class housing more quickly, more effectively, and to address the needs of the state?
Any other questions, comments from commissioners? Being none. Thank you very much, Dan.
Mr. Chairman, thank you
Pleasure
for the
to see you.
opportunity. Appreciate it.
Thank you.
Thank you, Mr. Chairman. Our next witness, who I'll ask to come up now, is Jennifer Hernandez. Ms. Hernandez is a partner at Holland and Knight, where she leads their West Coast Land Use and Environmental Group. She has practiced land use and environmental law for more than 30 years. Ms. Hernandez works for private sector, public agency, and nonprofit clients on a broad range of projects. She has written 3 books and more than 50 articles on environmental and land use topics, and regularly teaches land use, environmental, and climate law. And she graduated with honors from both Harvard University and Stanford Law School. Ms. Hernandez.
Welcome.
Thanks very much. Looks like it's coming up. Good. So I've got about 9 slides, and then I've got a bunch of graphic slides that'll show data if you're interested in diving into data more. I actually wanted to just augment that bio for just a second. So I grew up in Pittsburgh, California. Both my grandfathers and my father worked at U.S. Steel. My brother's a welder. My family's still in the trades. Pittsburgh has a lot more in common with Stockton than it does in my current home of Berkeley. And I mention that because so much of this CEQA debate is concentrated on pretty wealthy coastal communities that maybe it is possible to ride a bike to work. It is not possible for a welder to ride a bike to a pipeline job that morning. And it's also not possible for a welder, and I would argue it's not really reasonable for a welder to have to live in a backyard cottage and be a renter for life. And so I bring to you a different demographic. I teach environmental justice at USC Law School and have for a couple of years. I've taught at other law schools. And I just feel like people of California that need housing and need water and need transportation and need good jobs, somehow those people tend not to be front and center in a discussion of CEQA. And they should, because CEQA is about protecting the California environment and health and safety for all of us, including the environment, not for just a few people wealthy enough to live here. So I wanted to lay that out. I also wanted to say that my presentation, I think, prompted Sean's discussion about don't believe the data, because I've done the data. And this is informed by 3 separate studies, which I called In the Name of the Environment, 2 of which are law review, 1 was just published. But what happens in CEQA is every CEQA lawsuit has to get sent to the AG's office. And so we did a Public Records Act request and got copies of all of them over 3 3-year periods. So we have all CEQA lawsuits filed in the state for 9 separate years. We listed them, we categorized them, we invite anyone to come look at them. They've been published now for quite some number of years. And so what I'm reporting on is CEQA in practice. The other thing that we did, because I run a group of very patient lawyers at my law firm, and this is one of the ways to train them, is we looked over 15 years worth of reported CEQA decisions in appellate court cases. And those are really important because those decisions shape how CEQA is evolved. 1970, CEQA, Star Trek and Brady Bunch were in first run. We didn't have the Endangered Species Act or the Coastal Act. We didn't care about polluted land. Every factory used the backyard as their dump site, and we're living with that legacy. CEQA is kind of old. It's not as old. I don't feel like it's that old, but it really does predate every other environmental law. And so what is this about anyway? Why is it such an issue? And so looking at the judicial opinions, same thing. We looked at different kinds of CEQA documents, win-loss rates, and we presented them. So I want to use that data set to give you a little bit of a window into my 39-year practice of what CEQA means for real. Next slide, please. So, and it's a provocative title, I know, but so litigation risk is a huge driver of what CEQA requires. You don't do 2,000 pages of text to inform the neighbor. You do 2,000 pages of text because you may be in front of a judge who's saying, what about this? Where does it say that you've done this? So you're writing for other lawyers who happen to be on the bench. And when you write for other lawyers, I don't know if you guys know or are related to any, we tend to be a pain. And it's like, well, why didn't you do it? It just wasn't that hard. You should have done it. And so that's how you do CEQA as a litigation defense tool. And what are we talking about in terms of how weird CEQA is? So it is about 50-50. EIRs lose about 46% of the time. Not because some agency says, I am going to violate CEQA. That is my goal this morning. I want to violate CEQA and be busted in 3 years by a court. No, they're doing the best they can based on what they know, but judges really broadly interpret CEQA. And so there's usually one or two things. Well, why didn't you look at the juvenile stage of this fish? Why did you only look at adult? Well, that was the protocol. I don't know if that's the right protocol. You should have looked at juvenile. That was a Supreme Court decision. This level of uncertainty is unprecedented. Unprecedented. There was a discussion by this morning's panel of academics that, hey, lawsuits 50-50. It's true. If you and I get in a contract dispute and I think I'm going to win and you think you're going to win, we're probably going to litigate instead of settle. But if I sue the IRS because I don't want to pay taxes, the IRS is very likely to win for two reasons. There's deference given to the agency. Courts assume they did it right. Also, the rules have to be clear. If the rules aren't clear, how are you going to win? How are you going to lose? You have no idea. And that uncertainty is inherent in CEQA. Don't take my word for it. Professor Hecht and law professor Rick Frank, whom some of you may know from his AG days, said in a pleading filed in December, or in a case that was decided in December, CEQA claims are often litigated in an environment of uncertainty. Since the outcome of many CEQA cases are hard to predict beforehand, cases thought obviously unmeritorious end up being successful and vice versa. That is our environment. So a whole bunch of lawyers and consultants, none of whom are in unions, by the way, to the extent you want to support unions, CEQA is not the way to do it. We spend years and a lot of money trying to make CEQA documents litigation proof. This is not new news. In 1992, the Council on California Competitiveness concluded the higher cost of some EIRs often reflects the likelihood of litigation rather than the degree of environmental damage associated with a particular project. CEQA is a litigation defense game as it has evolved. And many things need a little refreshing over time. It's time, I think, for CEQA to be refreshed. And the legislature agreed. In 1993, with Mr. Scher, Senator Scher from Palo Alto, taught at Stanford, the legislature said, courts, dear courts, do not impose any procedural or substantive requirement in CEQA that is not expressly required by the statute or the guidelines, which should have put a cork in this. You want to require something new? We may not like it. We may have different views about it, but make it clear and courts will enforce it. That's what was decided. And the courts simply won't do it. They will not follow legislative direction. And that's a remarkable thing. And that has a lot to do with the way CEQA jurisprudence has evolved, starting with the 1972 decision by the California Supreme Court involving a condo project in Mammoth, where the court said CEQA should be interpreted to the broadest extent possible to protect the environment. Okay, let's start by using CEQA against condos in Mammoth. Next slide. This next point is just what it is that is the underlying reason this level of coin toss is allowed to exist. Everybody gets a little something from it. In the policy debate, petitioners, people who use CEQA to oppose projects and sue agencies, say agencies cheat, fail to comply. We need CEQA because we can't depend on laws and regs. Thousands of environmental laws and regs enacted since 1970, including those, for example, that require the cleanup of contaminated property before you can even think about putting a pipeline on it, let alone a home. CEQA analysis requires best available science. Excellent. Totally agree. There were more than 10,000 English studies, academic studies, per year on greenhouse gas alone. What is a planner in Hemet supposed to do to sort through what's best available science? I mean, honestly, that's what we have regs for. Yeah.
Why, based on what you're describing, and I would agree with you that most agencies, they want to do the right thing. They want to do the best that they can, and they struggle, and these documents become enormous. Two questions. One, why hasn't anybody said the law is so vague and challenged it on vagueness? And secondly, what would you suggest to do so that you don't have good people sitting in their office every single day spending all this money like, I don't know how to do it right because I've tried. I've spent millions of dollars to do it right, and I don't know how. Shouldn't there be a pathway to know how to do it right?
Absolutely. And to your earlier comment of this morning, we just had another case decision where an agency relied on what was a legal bright line rule. You didn't have to do more studies after a date certain. And the judge said, nah, you should have done more studies even after that date certain, and stopped the construction of homes mid-construction in a city, San Diego. And that's not unusual. We had one in North Natomas where homes were under blue tarps for 2 years while more CEQA was done in a location planned and approved in the North Natoma specific plan for exactly that kind of home. And the owners next door didn't like it. Doesn't, we don't want to look at that. Agencies, we often comply, but courts unpredictably require more. We lose even if we comply, and then we get 99% right. In real life, 99% is an A. It's a good grade. In real life, an EIR will pick up literally more than 100 impact issues, study them all, and then you'll get sued for 65, and then you'll get briefed for 30 in terms of what's actually in front of the court, and then you'll win 27. Project rescinded, project approval rescinded. A built and tenanted high-rise in Los Angeles that was built and had tenants was ordered evacuated because if you don't have a project approval, you don't have an insurable dwelling unit. That tower stayed unoccupied for years while everybody sued everybody, and more CEQA was ultimately done, and then people were allowed to move in. Who is served by that? Applicants. We can't predict anything. I'm not going to touch it unless you've cleared CEQA. I'm just not going to do it. That's normal. Affordable housing people, they don't want to touch CEQA. I mean, my God, they have timing and all kinds of capital projects. Smaller builders, forget it. People come to me and they say, I've done this great group housing thing. It's going to be affordable, or a multi-generation thing. It's infill. It's on 2 lots. It's only 3 units. They don't have the money to play around for 3 years and pay me and risk paying the other side when they lose 1%. And it's more often than not. And EIRs get sued about 70%. The biggest set of lawsuits is against EIRs because there's more stuff to pick at. The exemption categories that the UC Berkeley professors were talking about, they were 5 to 50 units. Those often are exempt. Exemptions hardly ever get sued. So you can play around. They looked at 30 jurisdictions? We looked statewide. Housing is the top target of CEQA lawsuits. 39% of all CEQA lawsuits in our most recent study. more than 1 million housing units at the plan level, the housing element update, the zoning, the sustainable community strategy. More than 1 million housing units were sued in the last 3 years. More than 48,000 approved actual project units ready to go except for the CEQA lawsuits, more than 48,000. And in the year we looked at, 2020, which was the 48,000 units, we produced about 110,000 units that year. Almost half of the state's production was challenged in CEQA lawsuits. What are we doing and who are we doing it to? We're doing it to the people who need housing.
So,
Next.
in anticipation of your testimony, I looked up a quote. Justice Robert Jackson, 1949, dissenting in a First Amendment case, saying the Constitution is not a suicide pact. You're describing a dystopian legal environment. If you had a magic wand and you could dictate an outcome that would pass the 60% political threshold, in other words, 60% of people would think it was a good idea in an institution close by, what would be the 3 things you would change?
So I get to that in the last slide, but it's politics, not policy, that is holding up CEQA reform. So anything that makes CEQA more predictable and less like something that, you know, you would expect out of Moscow or Beijing, right? If you know what you have to do, just enforcing that 1993 law by saying we really mean it, which is, by the way, one of the things the housing legislation did to a 1982 law that first declared California's housing crisis and said, cities, you guys got to approve what your plans authorize. Pretty straightforward. And for the next 40 years, courts said, yeah, but I'm uncomfortable. I don't want to do this. And courts wouldn't enforce it. Then one court enforced it. Everybody rediscovered it. It was like, woo. And the legislature came back and said, no, we really, 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 really mean it. And did a bunch of just legislative findings. They tweaked the language a little bit. But the courts recognize now the importance of those legislative findings because it's not 1972 or not even 1992. So that's one important thing. I'll get to the other two, and mine overlap with Dan's. Who benefits this CEQA status quo? Can you go to the next one? Okay. Cui bono. You got to have I'm a lawyer. You got to have some little Latin here. Economic competitors, we've talked about. Bounty hunters. There's a law firm in Southern California that charges 23 to 25 cents per square foot of warehouse as an extortion fee. Nothing to be done. Everybody goes, yeah, it's a bummer, huh? Some unions who seek job guarantees. I'm really sensitive about this because I'm a pro-union building trades Democrat, right? So a project labor agreement is not a prevailing wage deal. It's a deal to hire a specific union local for a specific project. So we had a high rise in San Jose where the general contractor was using Vacaville Union and the Santa Clara Union sued. It's a union agreement, not a prevailing wage labor standard agreement. And that was what the big debate last summer was between SB 6 and AB 2011. NIMBY preservationists seeking to block new people from their communities. I'm really, really, really irritable with these people because we already have a legacy of redlining. And this commission did a fabulous job on the homeownership study you did last year. And it was so right on. And I know that it got into people's faces about where we should build housing and what kind and for whom. But that was an important policy statement because nobody voted to end attainable home ownership for median income Californians. Nobody voted for that. But that is what CEQA is used for. And it's especially used by very green, very wealthy, extremely, from my perspective, politically incorrect, I'll just leave it at that, folks in places like Marin or the Berkeley Hills, where I live. Not here, somewhere else, but not here. Any incumbents who lose, they lose water, they lose money, they lose power from whatever agency decision is underway. Second to CEQA, lawsuits against housing, CEQA lawsuits against any water project. Guess what? You can't build housing without water. And to your point, this is not a one little more CEQA exemption for housing. Unless we have the water, the schools, the parks, the transportation, the jobs, we can't fix it. We have the highest poverty rate in the country on our watch. I mean, what do we do? And this should just not happen anymore. Lastly, is CEQA professionals. I made a lot of money in 39 years doing this. Really. But my dad lost his job permanently when US Steel closed, or almost closed, certainly got rid of a lot of union guys in 1985 in my first year of practice. And okay, fine, I don't have the luxury of, going off and being an academic. I work hard. But this is a dumb way to spend money when we have so many other needs. And it does not benefit union workers or households, all of the CEQA professionals. Next slide. Some call it the environmental industrial complex. Quimalo, who's harmed? Well, I'll tell you who's harmed is the people who don't get what it is they need. Housing they can afford to buy. 40% more wealth, multi-generational wealth gap can be closed just by making it possible for people to buy a home. And the 4-unit or the 4-story and above high density stuff that some people want, fabulous. It's not attainable. It's too expensive. Don't take my word for it. The Turner Center at UC Berkeley, solving the missing middle housing crisis. I'm looking at it, right? I'm like, this is very important. Accessory dwelling units, renting a cottage in someone else's backyard, and apartment units that have fewer than 20 units, which means they don't have to have expensive elevators and other systems. They're below 4 stories. Really, the best we can do for our teachers and nurses and firefighters and welders is renting someone else's cottage or living in what we call a dingbat in LA, really? And the answer is, oh, climate, oh, please. That's a whole other topic, which I can get into only if you want. These are the people who are hurt. They vote for more taxes, and then where's the project? Oh, the money's been spent on CEQA. A whole bunch of people have spent a whole bunch of years generating a whole bunch of paper. Next slide. All right, 3 myths and then solutions, and then I'm done. CEQA is necessary or should be expanded to protect environmental justice. Tristan's done a great job in planning this program. And I had some pretty clear opinions about the next group. There is no organization in the state of California that has sued to block more housing, including more affordable housing units, than a group you're going to hear from next called the Center for Biological Diversity. And they call themselves environmental justice. I don't. Environmental justice to me is civil rights, which includes, shall we say, a broader range, things like jobs and housing and actual livable conditions for people and attainable aspirational upward mobility for people. EJ is an important slice. We need to protect people in disadvantaged communities from polluted conditions. I get that. But CEQA is not about that. And in fact, Professor Biber, because there's been, we should expand CEQA to protect environmental justice, to protect socioeconomics, to talk about benefits. Expanding CEQA means expanding lawyer roles in CEQA, because that's all we're going to do. If you put it in a CEQA box, we're going to fuss with it. So Professor Biber, who you heard from, said, in research I've helped work on about how CEQA and local land use law is implemented on housing projects, we have found evidence that litigation and administrative appeals are more common in wealthier neighborhoods fighting projects. This suggests it's more likely that more privileged communities will use socioeconomic impact analysis challenges under CEQA to stop needed housing projects. And that's true. Think about who has the resources to file a lawsuit. Is it someone working 2.5 jobs? Is it someone raising 3 kids? Is it someone commuting 2.5 hours? No, it's people who are wealthy enough to kind of sit back and think, God, I really don't want those people here. Those people tend to be whiter and wealthier. I worked with the Southern California Association of Governments. We mapped every housing lawsuit in that region over one of our study periods, the second study period, which was published by Hastings Law Review, 78% of the anti-housing CEQA lawsuits were filed in the region's whiter, wealthier, and healthier neighborhoods. It's an exclusion tool. And the idea that it's needed for environmental justice, oh, please. If we have excess pollution, if we're trying to cite something without considering cumulative impacts, then we have environmental statutes, and if they're not strong enough, strengthen them. But make the rules. Don't rely on some haphazard introduction to an NGO that may or may not be available to file a lawsuit. That is not the rule of law. That is status quo. Almost last. Oh, two more quick myths. I'll be really faster though. Sorry about this. Next. CEQA protects the environment. Whose environment? In 1970, I was breathing air that you could taste in Pittsburgh. I learned to sail on a river that had a rainbow sheen from all the crap that was coming out of factories. I know pollution. I know Yosemite. We dragged our son to 100 national parks because we're nuts. This is not how CEQA lawsuits are fought. They're fought at the neighborhood scale in a legal framework that literally equates temporary noise impacts to climate change. It's a totally horizontal law. Everything is its own impact. Aesthetic impact, a water pollution impact, the same. It's dystopian. I like that term. We tried, and in a normal context would have been able to get CEQA back in a box that talked about disclosure, including compliance with all our thousands of environmental laws, which are pretty protective, I have to say. They're kind of well known as being pretty stringent, and they are. We should have been able to say, look, this is a new thing, Tesla or whatever, and here is what it does, and here is what it complies with, and do you want it or not? But instead, the people who want the ability to sail into any CEQA dispute for any reason, bounty hunters to environmental groups to everything in between, and only 13% of the CEQA lawsuits in our first study were filed by actual environmental groups, by the way. But what they completely rest their hands on, or their argument on, is our laws and regs are ineffective, inequitable, they lack additionality. They were produced by a corrupt political process in the legislature or in the agencies. I'm from Berkeley. I get protests, right? But you protest by electing people to the chair, your comments. You don't protest by these random lawsuits, mostly used by wealthy people, mostly against housing, because it's random. Next, and last of the myths. So CEQA is great at protecting my environment. If you think of my environment as a baby boomer incumbent homeowner, that's what it's really good at. CEQA is California's most important environmental law, premier environmental law. Would that it were. Because right now, when we say we need to do something urgently, we just exempt it. Groundwater is a crisis. Great, Sustainable Groundwater Management Act. Everybody go off and do plans. Well, we can't, we got to do CEQA. Okay, we'll just exempt CEQA. Housing, a crisis. Okay, we got to assign each local government an obligation to plan for more housing. Oh, we can't, we have to do CEQA. Okay, fine, we'll exempt who we decide has to build how much more housing under the Regional Housing Needs Assessment from CEQA. When we want to do something, we create a CEQA exemption. And every special interest who says, I want to seek a CEQA exemption for my thing, and you don't need to touch the rest of it, is talking on behalf of that special interest, not on behalf, from my perspective, of Californians who need this state to work better than it is. CEQA is also openly transactional, bargained away. You get labor and environmentalists, and you got your deal, Mr. Billionaire, Mr. Stadium, Mr. King's Arena. You got it. We'll make a deal. One time. Next. So what do we do to conclude? Next slide, sorry. Common sense policy reforms that have been blocked by politics. These overlap some with Dan's and anonymous lawsuits. This doesn't happen in federal law. You have to have standing. You have to say who you are and why your interest is protecting the environment. Ending duplicative lawsuits. Once a plan or project is approved, you can't keep suing over every later discretionary agency decision. It's one and done. Dan mentioned projects that have been sued 20 and 30 times, and that's exactly right. And they do take down not just developers and owners, but banks who finance them. And then the last in line kind of gets the prize, although the prize they get requires a lot more expensive housing. Match the remedy to the CEQA deficiency. 98% is a winning grade. It's an A grade. You don't undo the project, stop the project. If you have to do a little more study and mitigation, so be it, but no more rescissions. And then finally enforce 21083.1. Unless it's expressly required, judges can't require it. And then play around with whatever you want to do to make the more requirements. But they have to be clear. They have to be done in rulemaking or legislation. They can't just be done in random courtrooms. Last, policy disputes, though, are what we haven't talked about, I think, quite openly. And to me, that's what this is about. Some people believe California is over its holding capacity, and degrowth is needed. The climate people really have bought into this in a pretty official way in choosing a metric at the California Air Resources Board that says every Californian or job that moves out and no longer needs to turn on the light or the tap or fill the tank, that's a greenhouse gas reduction. Yippee-yi-yay. They go to Texas, their greenhouse gas emission triples on a per capita basis. They go to China, where we're importing cement, because China cement, when it hits the shore, has 0 GHG. Cement made in California, ooh, huge greenhouse gas emitter. I mean, who allowed that? But what it does is say, we don't want any of this in California. We don't want those jobs. We don't want those people. If you can't afford to live here and work in the keyboard economy, we'd rather you not be here. They're expelling us. And I identify with us. I'm sorry, I got scholarships, but I identify with us, people who can't afford to live here. And that's just not okay. And it's not global greenhouse gas emissions. California is less than 1%. We can solve with the same way we solved, according to the Obama administration, tailpipe emissions of smog. I mean, who knew? Catalytic converter, unleaded gas. We did it. And in 2016, Obama administration said we'd gotten rid of 99% of smog emissions from tailpipes. What an incredible environmental triumph. EVs we're about to go to. This is not about the environment or even climate. This is an anti-growth, absolutely discriminatory class and race regime, doctrine, religion, whatever you want to call it. It's snuck in, nobody voted for it, and it's administered in this totally bizarre way where even the Planning and Conservation League and a whole bunch of professors said, we urgently have to deal with water. We have to do some more CEQA exemptions. Well, that's right. If we have to do CEQA exemptions for everything, then let's just take a look at the law. And that's why I'm so grateful for what you're doing. That'll be it.
Great. Let me turn.
The next slide anyway, just in case anybody wants to see the slide.
Let me turn to the commission. Any other questions or comments? There we go.
So I'm going to come back to David's question. What are your 3 top things to, I mean, because again, I just don't, I mean,
So,
tweaking it is, to your point, it's a state law. So you shouldn't be able to come in and just say, well, I want this exemption, but everyone else lives under this rubric. You know, how do we all live under it? How do we all know, how do you know how to comply? How do you know, some people, some organizations, not just housing, but for example, let's say a factory, and they want to modernize. Well, the neighbor factory doesn't want to modernize, so your smokestack's going to be clean, their smokestack's going to be black, but all of a sudden, the one that's going to be clean can't afford it. So then you haven't cleaned up anything. You're both dirty because you can't afford, because you can't be competitive with the guy who's next door. So sort of in that vein, how do we move forward?
So require standing. That brings honesty to the litigation process. That means you have to disclose who you are and demonstrate that your interests are predominantly about protecting the environment. Labor unions do not have standing to file lawsuits under the federal equivalent of CEQA, the National Environmental Policy Act, or any other federal environmental law standing. That also wipes out competitors, and it wipes out NIMBYs who are worried about protecting their property values, which they usually are stupid enough to say somewhere in the record. Number two, end duplicative lawsuits. We're all in the business right now of trying to deal with the housing crisis. Each jurisdiction in the state is obligated to plan for more housing. Great. Each local jurisdiction, city or county, is required to adopt changes to their general plan to adopt more housing. CEQA trigger. Each general plan then has to have changes to the zoning code to actually allow for the housing and set development standards and stuff. CEQA trigger.
So where do you start that though, Jennifer? Do you start at the general plan?
General plan level.
So once you've done a general plan, if it fits
You
within
build
the
it,
requirements,
You're good to go. Good to go. We
Okay.
just have to implement what we've planned for in a CEQA compliant plan.
Okay.
And the CEQA compliance is presumed unless it's sued. And duplicative lawsuits. Third, match the remedy to the crime. If it's a 2% problem with an analysis, add analysis. But the reason everyone just freezes once CEQA is either unresolved or litigated is because you can be ordered stopped mid-construction or even post-construction and tenanted. So if you know you're not going to run into that kind of problem, and the way to do that is to only allow courts to stop projects when completing the project would really cause a health or safety impact, which is if that's an issue, you're putting a factory next to a preschool. I mean, okay, pause. But
How do
short
you
of a-
determine that though? How do you
Actually, the legislature's already done it in a couple of their buddy bills, I call them. So
Okay.
they've defined it. And the courts have defied it. They said, the legislature said that was the case for the state capitol project. And the court said, yeah, no, we're pretty interested in aesthetics and historic preservation. So we're not going to comply with that. And that is the last. Courts have to comply. And I would say that the same thing we did with the Housing Accountability Act, a bunch of findings that say we really mean it.
So to
Unless
David's suggestion,
expressly required by statute or regs, no court can impose it.
so to David's suggestion, what do you think of putting judges on a wheel and not having a sort of CEQA expert judges? What do you think of that?
So I will say that the judge education program for CEQA judges, which everyone thought was a great idea, had as its decade plus kind of environmental side instructor, the same litigator who stopped the Capitol project, who was found to have engaged in malicious prosecution of a CEQA case in an appellate court decision. And her actions were fully and full-throatedly defended by Professors Hecht and Frank as being utterly unremarkable under CEQA. So our CEQA judge system is broken. It's time to meet with Judicial Council, make a little bit more clear those rules, and shall we say, the bias that's inherent, even in who teaches CEQA courses, has to be peeled back. This is the most unbiased group I've talked to. You guys are really amazing, by the way, in years. When Hannah Beth Jackson decided she needed to hold a hearing on CEQA, she didn't even invite anyone to speak who wasn't looking to either expand CEQA or defend the status quo. I'm very aware, and as you know, you were my person in the assembly, and so I know, but I also know how this thing has been abused, and in my neighborhood and in Sophie Hahn's district. So, yeah. That's four things. Overlaps mostly with Dan's, but and they're all just good government things. I'm on like California Forward Board and whatever. I'm Coro Foundation. I think there's something to be said for good government, and these to me are good government proposals.
Thank you.
Thank you. Thanks for your time.
All right. I want to thank you for your testimony.
Thank you for your work.
Thank you, Mr. Chairman. The last two witnesses this afternoon, I'll ask them to come up now, are Jennifer Ganata and Aruna Prabhala. Jennifer Ganata, who will they'll testify together and then take questions. Jennifer Ganata is a senior staff attorney at Communities for a Better Environment and a member of the California Justice Alliance. Ms. Ganata previously worked at Communities for a Better Environment from 2007 to 2012 as a youth organizer and legal fellow. She transitioned from doing environmental justice work to housing by starting her housing career at Eviction Defense Network. Before returning to CBE, Ms. Ganata was a senior staff attorney at Inner City Law Center, where she did eviction, defense, and land use work. She has a bachelor's degree from UC San Diego and a law degree from City University of New York. She is joined and will be followed in testifying by Aruna Prabhala. She is a senior attorney and the director of the Urban Wildlands Program for the Center for Biological Diversity. She works to protect habitat for endangered species and limit sprawl. For her work against Newhall Ranch, a proposed mega development in Southern California, she won the California Lawyer Attorney of the Year Award. She's a graduate of the University of Michigan Law School and also Boston University. So Ms. Ganata will testify first.
Good afternoon. Thank you for having me. It's a little intimidating. I'm going to say that I've listened to a lot of today, and I'm, I think this is a great just conversation to have right now. And as somebody who has done housing and does environmental justice, like I do see how they intersect a lot. And I will say, I work at Communities for a Better Environment. We are an environmental justice nonprofit. So we are based in Southern California and Northern California, but we work specifically in communities that are impacted by environmental injustice, which can mean lots of different cumulative impacts in that community, right? So in Southern California, I am actually the point person in Southeast LA, along with another colleague there, but we also work in Wilmington. So we do a lot of oil drilling, working on that in terms of trying to stop that in neighborhoods and ensuring that communities are actually front and center in these conversations. I think when Tristan first called me and he wanted to talk about CEQA, and I was like, where is this conversation going? And after hearing today, I feel like it is very much targeted at housing. So I kind of wanted to touch on that. We have a housing crisis, but specifically it's an affordable housing crisis. And as somebody who has represented folks in LA and seen what's happened, it's not CEQA. CEQA is one of many other things that's happening in the entire state. And I think what isn't really represented here are folks who do work in the rural areas. So while I am part of CEHA and we do have colleagues in the rural areas, there are also very detrimental impacts that are happening in communities that are alongside agricultural fields, that are dealing with sprawl and lots of air pollution. That they're not here today, but I referenced it in some of my written testimony. There are just different things to think about when we're thinking about CEQA. And
you should know this is the first of a few hearings.
Yes.
So I don't think we're going to forget about the rural folks. Thanks.
And I appreciate that. So I did want to say how my organization uses CEQA is we are trying to figure out how to talk about projects that are in our communities. We do a lot in terms of stopping the bad. That's how we think about the work that we do in environmental justice communities. So that means like stopping things like Exide that was in the city of Vernon that really had an impact in East Los Angeles as well as Southeast LA. Also thinking about, I know you mentioned the ports, but also the expansion of the 710 freeway, the I-710, which would have had also a huge impact with the communities that are living along the corridor. And not to say that CEQA isn't about litigation, because there is a litigation piece, but it is also the cornerstone of it is actually the transparency part. I think there's been a lot of conversations about what that means. Like, what does it mean to have a project in your community? And I think for a lot of the folks that we are representing, they don't own land. They're not developers. In fact, I work in Huntington Park, where the majority of the folks that live in Huntington Park are 74% renters. So unless you get a notice of preparation, unless you are working on a project and you see something happen, you're not going to know what's happening in your community because you certainly just don't own the land. So I can go back to Exide. When they were talking about how are we going to do the cleanup, they had to do a CEQA process. They had to talk about exactly how they would do the remediation. And in fact, there was a lot of just reticence to actually do the cleanup that they ended up doing. And that actually hasn't fully impacted like the whole community. I think there are other places that still need to be remediated. The Department of Toxic Substance Control really at the beginning kind of pushed back on that. But I think through CEQA and through having community members know what was happening, they were able to talk about their concerns. So I bring that up to say that CEQA really is for environmental justice communities, a way to get a seat at the table to talk about what's happening.
And on the X side, they didn't want to clean the parking strips.
Right.
Where you park your car and you get out and you walk through the grass and drag it up, and so they clean your lawn.
Right.
But then you drag the stuff off the parking strip right into your house.
Right. And I think there was a conversation earlier about actually developing on toxic land. And I think that's where I actually wanted to talk about when we are talking about developing in environmental justice communities and why environmental justice communities need to know. Because the people who are moving into the building, they're not going to be able to comment. But the people who live in the community can tell you if that was a brownfield, can tell you if that was a foundry that was used for 100 years and was suddenly abandoned. Or if you look in environmental justice communities and you think about the number of orphan sites that are there, folks need to know like what is being developed upon. Because at the end of the day, it is really the environmental justice community that has to think about what's happening in their community and how do we do community-led solutions. And I know that sounds very cumbersome, but as an environmental justice advocate and working with our community members, we do believe in deep democracy. And maybe that's not fast moving. And I know that's hard to hear, but I even think as we're dealing with a housing crisis, we need to think about that too. We can't simply just build on top of toxic land and hope that it's not going to be a problem, hope there's not going to be vapor intrusion. And especially if we were thinking about projects that are looking to find low income or basically affordable land, you're looking at EJ communities to develop on. And that is like, while I understand there is a CEQA exemption for infill, but I think that we need to think about what happens in environmental justice communities, because we are looking at a law that it doesn't have a one size fits all solution. And I think that is the other part. I think Commissioner, I brought up, oh, well, aren't you all just saying that it's simply, it's another form of NIMBYism? I think though we need to think about the history of what created environmental justice communities and the racist planning practices that created environmental injustice to begin with. And I think we've had a lot of those conversations because we've had to go through CEQA processes where people were able to talk about redlining. People were able to talk about how freeways have actually torn through communities of color in Los Angeles area. So I'm happy to answer more questions, but I wanted to couch that in, this is for a lot of environmental justice groups, the only law for us to have these conversations.
So I said that to be provocative. I mean, I think that we have to think about what's going on here, but and I had a brief conversation with Professor Hecht about this. There are very few, and I worked as the general counsel of the Port of Los Angeles, so I'll speak to that. There are very few ports in the state of California. That is by design. The design was to put a very few number of ports to have the rest of the waterfront pristine. And so whoever decided to put housing next to that industrial area, well, that's a unique discussion, but it's where it is now. But those decisions were by design because California's coastline is the beauty of what California is. And I think people have seen through what happened during the pandemic, I mean, what those ports do and what they contribute to the economic power of the nation. So I just, when I said, it's a form of NIMBYism, it was to actually get people thinking and to sort of be provocative. But at the end of the day, there was design here. And so as everybody has testified today, as we're talking about this, it is very difficult to be a strong advocate for aesthetics if you cannot eat. So if you do not have a job and you cannot buy food, whether or not there is a tree is not going to get you to the next day. And I think that's really part of what's being discussed here is, are we making progress? Or are we just spinning our wheels so that lawyers like me can, have money in our pocket? Is there another path to still deal with these issues that you're talking about? And the question is, all of this other regulatory framework, the Clean Air Act, the Coastal Act, this, that, and the other thing, are there other tools other than just this one and how this one's being applied?
Right. And I think, so this is also, as I was listening to the different testimonies this morning, as people, we are also still part of the environment. And I think separating out what are the natural environment versus people in the environment, I think that is also how we need to think about when we talk about CEQA, that people are a part of the environment. It's not a separate piece, though. And I think when we're talking about the ports were created and then there are communities there, there is also that process. If we were thinking about where are we siting the housing and thinking about how do we have a better project, I feel like that's what CEQA does though now, right? We can talk about, if we put a project here, how do we think about the community that's already there right now? And how do we actually address the different issues that are happening?
And I hear what you're saying. And I think that's a very fair point. I think other people would say that there are other tools in the toolbox as well. And so maybe there's a way to look at CEQA, and maybe there are some abuses with that, maybe not. I mean, we're here to listen, but I think that's what you're hearing, is there are other tools in the toolbox. But I don't think you've heard anyone on this panel, I don't want to speak for everybody, but saying you shouldn't look, you shouldn't take that into consideration. I think I can speak for me personally. I think it's very important to stop and look and be transparent. The question is that what this is doing, or is this doing other things as well?
I'm
sorry.
Go ahead.
I just to follow up, I don't think anybody here said, or any of the witnesses have said it's all or nothing, right? I don't think we're talking about eliminating CEQA. I think we're just trying to understand why it takes so long to get through the process. So the folks that you advocate for, how are they better off if a project is delayed 3 years, versus 6 months? I think that's what we're trying to understand and struggling with.
Right. So I'll talk about the 710 project. So the I-710 would have effectively, one of the proposals was to double the size of the freeway. So it would have gone from 4 lanes on each side, so 8 lanes altogether, to 16. And we know now through a lot of research about public health, that corridor actually experiences some of the worst air pollution in the South Coast Air Basin because of particulate matter from trucks, et cetera. And when the proposal came up in 2002, around 2000, I think as the coalition that I'm part of, which is the Coalition for Environmental Health and Justice, which includes CB, as well as our partners, East Yard Communities for Environmental Justice and Long Beach Alliance for Children and Asthma. And we have legal partners, Earthjustice and NRDC, and the Legal Aid Foundation Los Angeles. What we started to see, though, was it was simply about the economics. So if we just were able to put more trucks on the road, this would be better for everybody, but it clearly wouldn't be for the folks who live along the freeway. And I think when we talk about environmental justice, we are talking about public health. And I think so that project took a really long time. There were a lot of hearings. There are a lot of conversations of different cities. Caltrans actually had metro area in Los Angeles do the planning for it. And as of 2021, the project did not go forward because there was no way that project would go forward because of the clean air issues, right? That it would never get into attainment. But in that process, we did have a conversation what it means for freeway displacement, because it would have caused houses to be displaced, so communities to be displaced, families and businesses. It would have also not have had any conversation about zero emission vehicles, which we are now having. Before there was no conversation about how do we electrify. Now we're looking at different infrastructure issues, like how do we get those jobs? And also the third part was, well, we want to also ensure that if there's a project coming into this area, how do we make local targeted hire? Because people do need jobs and we understand they're all connected in this way. So there's an environmental justice issue, there's an economic justice issue, but how do you make a project actually improve the lives of people and not create a status quo? Because it was also about how do you get the air pollution down? So in that respect, it took a really long time to just get where we are now. And we are still having those conversations in Metro. And it takes time for people to even start talking about equity. In the beginning of that process, no one was talking about equity. No one was talking about the communities that were being impacted by the trucks and the air pollution. And so I think for the communities that we're talking about, we're saying these are our issues and we need to be heard. So to your point of like, delay, I think especially if you don't actually, I myself, I'm a tenant, right? And I actually live in rent control, so I have that. But in a lot of ways, if you don't have a stake and seat at the table, how do you talk about your community? Like, how do you organize within your community unless you're able to talk about the things that you're concerned about, which, is air quality in Southeast LA. It's about, now it's really also talking about displacement. How do we ensure that we have projects that are coming in that are good for the community that aren't going to displace the folks who've been organizing for decades there?
Okay, you're doing just fine. I think part of what I'm hearing, and we haven't heard from the other witness yet either, is that there are a number of quality of life issues and health issues that may not have a home. In other words, based on your experience, and this should be part of what we look at also as a commission, if you were a resident along the proposed 710 corridor, and if you wanted to raise the issue of air quality, and if you don't have CEQA, what do you attach yourself to in order to elevate that to be part of the conversation? Where else do you go when you're a fence line community,
right,
impacted by prior decisions having to do with environmental quality? Which tool do you have available to you if what we are saying is part of the problem or part of the challenge with CEQA is that it has been expanded to include a number of categories that have to be part of the report, okay? So if it's not within the list of CEQA considerations and you are being impacted by what's going to happen, not talking about housing now, but talking about freeways, talking about warehouses in Fontana, San Bernardino, Redlands, Riverside, where do you go to let somebody who is in a position to make a decision to protect your interests? What door do you knock on, right? What number do you dial? Which agency do you embrace to say, can you hear what we're saying? And do you have the authority to make these people do what they need to do to protect us? And that right now, what you are telling us is the vehicle for that is CEQA.
Correct.
Okay.
And I just, I wanted to conclude because I actually think that Aruna has a lot of great points in talking about how we move our litigation and what you can use CEQA for and what CEQA isn't. I think that CEQA has helped environmental justice communities shape what their communities look like now. And I heard a comment earlier today, what if you don't have an advocate? And I think that happens often, but in sharing this information and being able to, I think, Chairman Nava, you talked about civic engagement. Part of that is here also, because you're able to talk about your community, and CEQA really puts that in the forefront. Communities are the experts of their neighborhoods. Community members have an expertise that people who are working on plans don't know about. And I think what becomes hard is because I know that there are other cases that are not the best CEQA cases, and those are the ones that get the attention. But there are so many CEQA matters and EIRs that happen that made better projects that have actually helped the public health in general of all of California, but also in environmental justice communities. And I think that doesn't get written about a lot because that's not as provocative.
I mean, part of what, and I'll go to you next, but, part of the impression that I'm getting is, I had friends over at Cal OES, and every time California had a problem, whether it was disaster related or not, it went to Cal OES. Oh, we got to get COVID stuff out. Give it to Cal OES. Oh, we've got housing issues. Oh, let's give it to Cal OES. So Cal OES became a victim of its own success because they were nimble and they were smart and they knew how to apply resources to get the answers that the governor wanted. So every time something happened, Cal OES was part of the administration of solving the problem. And part of what I'm learning today from all of the witnesses is that CEQA has become, in a way, the Cal OES of a whole host of issues. It's the place where the concepts are now inserted because it's an organism that, right, hasn't choked itself out yet. And part of what we're hearing from people is, you know what, maybe a lot of this stuff shouldn't be there. Maybe there ought to be a better place for some of the issues that need to be resolved. But for right now, Cal OES, I mean, not Cal OES, but CEQA is where they get put.
So I'm by no means a CEQA expert, although I did write a law review article on it many years ago. But this has been an issue that's been around for a long time. And my question to you is, are you okay with the status quo of how it's used, or do you think that there is room for some improvement to it and modifications to it at this point in time?
I think for most communities, I would be hard pressed to hear, would you rather have somebody make decisions about where you live without people knowing what's happening? I don't think anyone would really want that. I do think that, I think it was mentioned before, there are, even if there wasn't CEQA, there would still be legal challenges. And I think that's like a really huge point to bring up, that CEQA is just one of these things, but it's really not the thing that's impeding, like say if we were talking about housing in general, that's not the only thing that's happening. We can think about land speculation. We can just think about resources in general. I wouldn't say it is the status quo because I think communities have the right to talk about what's happening where they live. And when I talk about environmental justice, the state of California is one of the few states that actually has the definition. And it really recognizes that everybody has a right to clean air, clean water, clean soil, regardless of who you are and where you live. And it applies to where you live, work, and play. And so I think that it may be difficult to hear, but I do think that the real issue here is that when you have affluent communities not wanting to actually have housing in their communities that are multifamily, that is a fair housing issue. That is an issue of talking about, that's a hearts and minds issue. That has to do with lots of different ideologies that we're not talking about in CEQA.
Which I think you're kind of making the point that CEQA is probably not appropriate for that type of activity. I mean, so in my neighborhood there, there was an initiative to provide, there was some vacant lots to put tiny homes in there to integrate the homeless within the community so they could be part of the community, provide services within that. And that was in areas was outright rejected. And I thought that was very unfortunate because everyone out there wants to solve the homeless problem, and here's an opportunity to be part of the solution. And so I don't know if I don't think CEQA is the proper venue to require project labor agreements. I think that's abhorrent. I don't think that is what the California Environmental Quality Act was ever designed for. So, and then when it comes to neighborhoods, there are affluent neighborhoods or even people who think they're in an affluent neighborhood that don't want multifamily housing. And sometimes those are the right projects for your community. And in fact, in a community that is looking for better jobs, when you have projects like that, the jobs, the industry will come to those places. So, so my question, I don't disagree with you. And by the way, I think I don't think anyone here wants to see building on toxic lands. And I think there's probably some environmental regulations on that. Again,
Right.
I'm not an expert, but the goal of the commission here is to determine if there's some appropriate recommendations to make to improve CEQA at this point in time. It's not about gutting it, getting rid of it. It's to improve it.
I think, so I'm gonna let Aruna talk about this part, but I also do think that CEQA and an AIR process allows the community to have that conversation. And yes, some people will oppose, but everyone gets to oppose, but that doesn't mean that project won't go through. You can still do a statement of overriding considerations. You still have that fail safe in CEQA itself. But if we're saying that no one should even have that conversation, maybe that is also part of the entire process of that dialogue of why don't you want, whether if you're talking about tiny homes, why don't you want that here? And I think I feel like if I worked at a city, I would like to facilitate that conversation somehow. But that's just me speculating. I do think that we're probably a better society if we have democracy in that way.
I don't disagree with you with that whatsoever. It's just it's whether CEQA should be the right tool to try and prevent that when it's preventing that conversation.
Let me ask, is this a good time to share with Ms. Prabhala?
Sure.
Does that make sense?
Yes,
Okay.
absolutely.
Thank you.
Ms. Ganata. Good afternoon, commissioners. Thank you for this opportunity to talk to you about CEQA, the state's bedrock environmental law that has done so much to help our environment and empower communities. In my work at the center, I have spent the last decade pushing for more sustainable and climate resilient development while challenging environmentally damaging projects, ranging from ill-conceived sprawl to polluting warehouses that threaten the health of communities throughout California. Because of CEQA and the center's work with environmental justice and community groups, many of these challenges have resulted in cleaner, better, more environmentally friendly projects with fewer impacts on the surrounding environment and community. Now, I have to acknowledge, I had a presentation I want to go through, as you can see probably from my many pages, but there are a couple of points that I want to clarify and bring up based on this very interesting conversation we've had today. So I'd like to start there before I dive into some of the things I raised in my written testimony. I want to clarify the CEQA process. Some of the discussion today made it appear as if CEQA begins at the courtroom or at a lawsuit. That's not how CEQA works. Before any lawsuit is filed, there is an extended administrative process, a process where a project is proposed, details about that project's analysis about its impacts, whether those impacts are going to be significant, are shared with the community. Members of the community, people who have an interest in it, are allowed and required to submit comments to raise their concerns. If they don't engage in that administrative process, the courtroom doors are closed to them. They have to raise their concerns with the agency and the developer. And the developers have multiple opportunities, as do agencies, to address those concerns, to explain why the project is developed this way, to provide evidence to say, we understand that, but their technology isn't there to fix that, or we had to balance these different concerns. Those decisions have to be supported by evidence, but that agencies are not shocked by what happens at a lawsuit. My staff, we spend hundreds of hours before we ever file a lawsuit, submitting extensive comments, attending public hearings, often in pretty lonely rooms where it's just us and the city council or the planning department. We talk through the concerns. We're available to talk about the things we're concerned about and want to have opportunities to address these concerns. And then when an agency finally chooses to make a decision, if there are environmental impacts that they cannot mitigate to a level less than significant, there is an opportunity to adopt a statement of overriding considerations, as my colleague mentioned, which allows an agency to say, because of social, economic, legal, or other benefits, we need to move forward with this project. We have the evidence to say why this is true. We have heard the concerns, we've addressed them, and we want to continue to move forward. And that is a really important part. One of CEQA's main goals is balancing interests. It's balancing the need to protect our environment, to allow communities to have a voice, along with having progress and moving forward. CEQA is not an impediment to progress. It's a guardrails to progress to make sure that progress doesn't come at the cost of our community and environmental health. I also want to clarify that lawsuits cannot stop projects. Just because I don't agree with a development project, I can't just go into a courtroom and say, stop, 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 don't do this. I have to engage in the administrative process, and I have to demonstrate in my comments that there has been a violation of the law, that you haven't complied with CEQA's requirements, that you haven't provided evidence to support, or you haven't done enough to mitigate the environmental harms. And the environmental harms I'm talking about, that's an abstract word. Let's get into what some of that might be. It means, is there enough water supply for that project that housing project you're building? Is it built on toxic land? Can communities plant fruits and vegetables in their backyard? That's an environmental harm that should be analyzed. If you don't fully analyze that, environmental groups and community groups should be raising those issues. Hopefully agencies have addressed them, but in places when there haven't been, CEQA allows community groups and environmental groups to hold them accountable. Explain your decisions before you make them, because these land use planning decisions, where they're warehouses, freeways, housing, sprawl, they affect our landscape for 10, 20, 30, 40 years. And CEQA often presents the only opportunity, the moment to look before we leap, to think critically about that. Because once that door is closed, once the CEQA approval process is done, you can't go back and say, hey, maybe they should have put a couple more EV chargers for that community so that we can transition to more electric vehicles. Hey, maybe they should have double checked that there is going to be reliable water sources in a time of climate change. I get outreach from community members, from the center members being, hey, I just heard this project's coming in. I'm really concerned about it. And then I ask, okay, where are they in the environmental review process? Oh, the city council approved it last week. I have to tell them, I'm sorry, that we need to have engaged in the administrative process to raise our concerns. The other point I want to clarify, and while I think rightly so, this panel and this discussion is about CEQA as a statewide issue. My organization, the Center for Biological Diversity, which I am very proud to work at, was attacked by earlier comments saying that we have challenged more affordable housing projects. I need to push back on that. It is true the center has filed lawsuits challenging projects. We've challenged oil refineries in that are abutting against people's backyards. We've challenged warehouse projects that have demolished homes in order to build logistics centers near communities, near schools. And we have challenged sprawl projects. I won't deny that. But the sprawl projects that we've challenged have tremendous environmental and community impacts. And I'd like to just talk about a couple of them. One of them is the Otay Ranch Village 14 project in San Diego. This was a project that included no affordable housing. It had significant greenhouse gas impacts that were going to be mitigated through the dubious offset program. It was in a high wildfire zone, which presented not only significant concerns for new residents, but existing residents. And we challenged that project. And you know who also joined us in that challenge? The Attorney General, because they were concerned about the wildfire impacts and the greenhouse gas impacts. And we won in the courtroom. Another project we've challenged, the Guanac Valley project up in northern Napa County. This is a luxury resort and development project with polo fields and helicopter pads. It was covering over a 16,000 acre space. It included no on-site affordable housing. And we challenged that project. Again, the Attorney General joined us in the litigation because there was concerns about the wildfire and greenhouse gas impacts. And we also won in that lawsuit. And that project, the AG has now settled to have an evacuation plan that's going to better allow the nearby community to evacuate if a wildfire comes through, which is particularly important because the site of that project was on fire when the project was approved. So yes, we challenge housing projects, but we challenge the worst of the worst housing projects that simply have not done enough to address environmental impacts. And we don't stop those projects. We push them to do better. Another project I want to talk about is the Newhall Ranch case. Now, this is a project and a development through our litigation and the settlement agreement is now dubbed Net Zero Newhall. Because of our litigation, the developer agreed to put 25,000 new solar, 10,000 new solar installations, 25,000 electric vehicle chargers, and residents are now moving in to that community. So we can have CEQA, we can have engagement in the process, and yes, we can have CEQA litigation, but it doesn't mean housing doesn't get built. It simply makes sure that the housing that is built safer, more sustainably, and more protective. The last thing I want to clarify is that I want to push back on some of the discussion about CEQA lawsuits. In the CEQA process, not every project undergoes an EIR. There's a whole host of exemptions. And when we talk about CEQA reform, I think it's really important to look at what exemptions have been passed in the last couple of years, what reforms have already taken place, because there have been changes to CEQA. And before we make further changes, we should be careful and thoughtful about what has already been done and what the impacts of those changes are. There were several changes already done in the last legislature. We need to see how those changes are actually going to play out on the ground, perhaps before we do more, because of the incredible good CEQA does have in our communities. The number of CEQA lawsuits remains consistently low. Only about 2 out of every 100 projects is challenged through litigation. And now earlier, there was a comment made that EIRs are the biggest source of CEQA litigation. Well, there's a reason for that. Environmental review under CEQA can look in very different ways. There could be a negative declaration where an agency looks at a project and says, there's not actually going to be significant impacts. We can move forward here. There's something called a mitigated negative declaration where, okay, there are some environmental impacts, but we can resolve them. And with them, there's less than significant. And for some of the really big projects, they do an environmental review. And it's not surprising that a really big project that's going to have a lot of impacts, that's going to pave over thousands of acres or bring 14,000 truck trips past through to Moreno Valley, like the World Logistics Center, is going to require substantial environmental review, and that some people may have concerns about it and raise those issues. So I think that's an important thing to keep in mind.
Yeah, but that Moreno Valley project was approved, and so now those trucks that's through my neighborhood. So I wasn't really happy with that approval. But those I don't know, how that plays into the solutions on that, but that's one project where it was ultimately approved. And now there's no freeway infrastructure for those trucks to come through our neighborhood.
So I was involved in that World Logistics Center, and I fought that case and was involved in it. It is a very large warehouse project, and we challenged it. We weren't alone. Other people challenged as well. Other agencies challenged it as well. There was a significant amount of concerns to the community. Again, it shows. I do think that, unfortunately, it does show the limits of CEQA litigation. The project kept getting approved. Moreno Valley chose to approve it again. So eventually we did enter into a settlement agreement. We were able to get in things like air filtration systems for nearby communities, things to reduce the noise impacts. Noise can sometimes seem not that important, but live next to 14,000 truck trips and noise seems pretty dang important, I think. We were able to get some more greenhouse gas mitigation measures, protect a nearby wildlife area. And so we were able to do that with the CEQA process. But I agree, I don't like that project. But CEQA is not the end all be all. It gives us a place to raise our concerns and hopefully push back. And hopefully we have engaged agencies and willing developers who will listen to those concerns and make changes to those projects. We've certainly come into settlement where we've included free transit passes for new residents, more solar panels, rooftop solar on low-income multifamily units, affordable housing units, more EV chargers. That all can happen through the CEQA process.
I'm going to take this opportunity. I've enjoyed learning from you this afternoon. I've enjoyed listening to all the witnesses who've been testifying. This is something completely new for me. in terms of where I am. So it's been particularly helpful. But I enjoyed your passion and your articulateness, and it comes through. But I have a couple questions for you. I'll save the third one till you answer the first two. How many lawyers do you have in your organization, and how many lawsuits did you bring last year, for example?
So I don't know that number off the top of my head. I'm happy to provide it to you later. I can say for my team, I run the team that focuses on land use planning in California. Okay. I have 4 attorneys, and we
full-time
attorneys
dedicated to. They don't work for someone else and come in part-time.
I certainly hope not. No, they're full-time staff attorneys.
Okay,
we keep them pretty busy. They don't have time to do much else.
Okay. And then the last question, since David Breyer's not here, it's a question that occasionally I ask too. If you were past the magic wand, you're obviously in favor of how the Operation Watts works to some extent, maybe to a great extent now, but if you could make 1 or 2 or 3 changes that from your perspective would be helpful to the community that you serve, what would they be?
Well, I think one of the changes I would make is ensuring that communities are able to engage and know what's going on with these projects. So noticing requirements to make sure that a teacher or somebody who wants to know what's happening is able to see it. So those are available digitally online. Translation is a really important issue, particularly in environmental justice, low-income community groups. Documents should be available in Spanish so that people can understand them and be able to engage and participate in the process.
An excellent point. Go ahead.
Oh, I was going to say, ensuring that cumulative impacts and that that analysis is done so that there is really an inventory of all of the nearby projects, because so many of our environmental issues are death by 1,000 cuts. A single project in isolation, maybe that doesn't look so bad. Oh, but did you know that there's another massive warehouse center just a little bit down the road, and there's also an oil refinery, or there is a whole other host of other projects that are polluting? I think making sure that that disclosure is available, that's clear, and so that environmental justice communities, environmental groups are concerned about the overall impact that we're having. Because issues like climate change or cumulative impacts, I think those would be the direction I would head if I could refine CEQA.
Right. Did you have a question?
Yes, I do. You laid out earlier the administrative process that allows for political participation before any lawsuit or we get to the litigation part. The Department of Healthcare Services and the Department of Social Services, they have at this point a very robust mechanism for stakeholder engagement. I'm very curious within the CEQA process, where do those mechanisms exist? Are they at the county? What are there other agencies or branches of state government where those are actually both not just resourced, but there's actually mechanisms or counterpart agencies on the ground that does that? Because I think that's, to your point, we can't plead ignorance if we did not participate in that process, but is that process both accessible and accountable? Because it could account for many things, including what you're pointing out around equity, around language access, around food and healthcare access. There's so many things that can be addressed at that level that doesn't get us to the stickier parts of litigation. But I'm just curious whether those entities exist within the implementation of this law.
So I think I can touch upon this, but I don't know, Jen, if you want this as well. So I think CEQA, because so much planning happens at the local level, at the city and county level, cities and counties are sort of charged with deciding how their communities grow. That is the place where these conversations happen. I think that certainly there can be ways to ensure that conversation and that everyone can participate in that conversation. We've seen sometimes during the pandemic, hearings are only available on the internet. But what if you don't have a reliable internet connection? Or what if the hearing is that 2 p.m. and you work a retail shift, you can't go? Or what if the hearing is at 8 p.m. is only at 8 p.m. and you have kids at home? So I think there are questions about ways to improve accessibility and access, because these discussions are really important. And I realize they take time. Like, I'm not saying that, CEQA we can just move very quickly through that process. But the questions that are being asked during the CEQA process, I think warrant the time. Because when we have a new resident move into a house, we want people to move into houses, but we want people to move into houses that are safe, that they feel comfortable in. And if we don't take the time to ask those questions, then we're not really doing justice to our communities. But Jen might have more there.
I was going to say that in terms of outreach, it depends on also the lead agency. And I think that also becomes a conversation. Like, once you find out about what a project is, like, you have to start thinking about what is the public outreach looking like. And going back to, I think, COVID-19, which was really difficult, especially for a lot of our members. I mean, my organization had to figure out how we were going to get folks computers to just actually, and also then have to show folks how do you open up your computer and use the internet and all these different things that had to happen in order to have our community members actually participate. So that isn't really addressed in the public outreach process. I mean, it really does depend on if the community finds out, and unfortunately, I hate to say that, it really does depend if you have a group you can go to talk about how will we access this information? How can we have some sort of comment and review process? So it varies, I think.
Yeah, I just, something that happened to me years ago that really underscored the difference, right, in my life and others. And it was early in the morning. I was at a Winchell's donut shop buying a cup of coffee and a donut.
That was your bad taste.
I know, yeah. And
Go ahead.
so there was a young man behind the counter, probably in his 20s, and we started, talking, and he said, "¿Qué es su trabajo?" Goes, "What's your job?" And, so I stood up straighter and I said, "Soy abogado. I'm a lawyer." And he looked at me, he didn't blink an eye, and he goes, "¿Qué es su otro trabajo? What's your other job?" It was inconceivable to him that I only had one job. And I was just dumbstruck standing there, realizing how stupid I was because of the assumptions that I made about how other people were living their lives. And so when we talk about access, we can't forget that one of the things that we learned during COVID was that school children sitting in a McDonald's parking lot, because that's where they got Wi-Fi, right? Scrunched up on a curb, and they had an iPad, or they had a tablet to use. We're not even talking about the households that have no internet access, the digital divide, don't have computers, don't have tablets, they may have phones, but that's a small screen. It's kind of hard to do your homework on that small screen. So I do think that what we have seen become more important over recent times is the focus on environmental justice and understanding and broadening the definition of what it means and how people are disadvantaged by the things that get in their way.
So can I ask a question? Thanks. So I'm trying to balance, I get the access issue and all of that, and I don't think it's just a CEQA issue. It's an issue across all governmental agencies, no matter what level they are, right? Oh, I'm sorry. In that particularly the pandemic has shown that, right? That I sit on a bunch of boards and all of these kinds of things, right? And we're always dealing with the access issue, language issue, all of that. But in general, I'm trying to figure out, because hearing from people who testified earlier in the day, it appears that there are times when CEQA can go on forever, right? That there are ways that people can use it in order to introduce a new issue as you are 90% down the road thinking you're going to get something, and then someone raises a new issue and maybe they have to kind of start all over to back up on that issue. So is there an acceptable time frame that you have where you can say, you know what, after blank number of whatever it is, months or years, there has to be a finality here. You just can't keep going, because eventually what we hear is the developer either says to themselves, I'm not getting involved in that community because I will be stuck forever, right, in the process. Or the process is going to take so long that eventually the financing goes away, right? And that could be for affordable housing, it could be for low-income housing, all of those kinds of things. So I'm just interested in this balance of timing, kind of. Is there it cannot go any longer than 3 years? I mean, and that sounds to me like a huge amount of time, but I have no idea. Do you guys think about that?
So I hear the concern that you're raising, and I think I want to clarify a couple of things. There is a set sort of steps in the environmental review process. There's a notice of preparation. There's sort of decision about what type of environmental review is done. There's a draft of that's then circulated. Folks submit comments, and then there's a final EIR. There are strict engagement requirements. If I submit comments for the first time after a final EIR, the agency doesn't need to respond to those in their EIR comments. I don't want to get too much into like the specific weeds, and because it's late in the day, and I don't think people want to hear me start talking about public resource code sections. And so, but that process is driven by agencies. Agencies are the ones who are moving the process forward when the environmental review is done. And so as a community member or a petitioner group, I don't have that control to keep pushing and keep extending. There's set comment period deadlines. Sometimes we have 30 days to review EIR, sometimes we have 45 days, sometimes longer. In the sense of a new issue being 96% of the way done, and then you have to start all over, I think this is an issue. This is what happens when you speak in abstractions rather than specifics. An issue that you're 96% done with a complicated project that is making you start all over, that's probably a pretty big issue. If it's an issue of that's requiring a fundamental redesign of a project because of an environmental impact, that environmental impact, one would assume, is so significant that it's made you rethink the entire scope of the project. Is it something where there's discovery of toxic soil on that might be something we might have to go back. If there, a loss of a water supply, it's just if it's a truly minor issue, I don't know why they would require you to start your whole housing project all over again. And if it's something that is making you rethink your entire project, that's probably something important enough that maybe we should think about it. Because again, when we make these land use approval decisions, they have long-reaching consequences for our communities. They have long-reaching consequences for our environment. And so, I think that's and that's my experience having done this work on the ground. We often push for a recirculation of the EIR, but it's a very rare situation where at the final EIR stage, you're about to approve the project and there's a 11th hour moment you come in and no, start all over.
Mr. Chairman.
Mello?
Yes, I think, first of all, your arguments are very compelling. And I think that's the reason why nothing can ever be done with CEQA, because each side is so compelling, either they have issues with it or why we should keep it. But I will tell you, I'm not an attorney, I'm an engineer, and I work in the CEQA world all the time. And there are good projects that are held up all the time, whether it's a home for foster kids, or it's affordable housing, or it's a park, or it's a road that's necessary, right? So there has to be something that we can do to CEQA to protect the communities that you're talking about, but also we have to be able to build projects as well. I'm gonna give you two examples. One is, I was working on a project and it wasn't that big, and a EIR was done, and an attorney kind of just flew in. Obviously, he did all the things that you talked about, right? And held the project up for a long time. And then ultimately he just got paid off and he went away. So the project didn't change at all. It was exactly the same project. He just made a bunch of money. And that's very unfortunate. The other one is, when I was in the legislature, when the state started experiencing all these wildfires, we were trying to figure out what can we do to try to mitigate this. And we had folks in talking about like the power lines and the tree, they would cut the trees down a certain distance from the lines. Well, with climate change now, the winds are a lot more powerful in these canyons, and they have to go now further because what happens is the winds come in, they blow these trees down, they go into the lines, they start these big fires. And I asked them, what's holding this up? They said, well, we have to do an environmental impact report, and it takes a long time to do it. And then we get sued because there are people that think we shouldn't cut down any trees ever. And consequently, we keep having fires. And I think all we're talking about is how do we mitigate that type of thing? Not put freeways in minority communities, not try to have people live on, toxic soil, but there is an in-between, right? So today we have argued both extremes, but I think there's a couple of things we can do in the middle so that we can have a society that's functioning. So that's my thought. I don't want to get rid of CEQA. When I was an elected official, I very much enjoyed CEQA. I don't want a soap factory being built next to me. I want to know what's going on. And I certainly understand about the communities that don't have the resources to stay in tune. And I think we need to do better. I think right now it's like a 300-foot disclosure. We need to do better than that, right? But there's got to be something that we can do just to move our society forward. So.
I really appreciate that comment. And, I certainly don't want to speak for all CEQA petitioners. That's not a task I want to take on. I can speak for the work that I do and the groups that I work with, and I'm proud to work with. I think, and I do want to acknowledge that we do, as Ms. Ganata was saying, we do have an affordable housing crisis, and some progress needs to be done. But I think hopefully one of the takeaways that will come from this is that the housing issue is an incredibly complicated one, and CEQA is just a small little pebble on that giant mountain. And there are solutions to solving the affordable housing crisis that I think we need to look at if we want to address this issue. Restricting the use of single-family zoning, supporting anti-displacement measures, direct investment in affordable housing from our government agencies, placing limits on the use of housing stock for short-term vacation rentals. Those are all places where we should be putting government resources and energy to very much address the issue of affordable housing. And I think we should also take into account CEQA is a living law. It's not a static law. If you look at the report by the Housing Workshop, and they have an appendix of all the exemptions and changes that have gone to CEQA, it is pages. There have been amendments to allow to streamline affordable housing, to streamline infill housing, certain types of transit projects. And so I think those who work on CEQA, care about CEQA, aren't operating in a vacuum, but I don't think CEQA can be the place or even the primary place to sometimes solve some of these bigger problems. If we really want to increase affordable housing production, we have to look at some of these other issues, some of the decisions and choices cities and counties are doing. I don't envy you that task. I focus on my CEQA litigation, but I feel like that's a place where there's empirical evidence and studies that show we can make some more progress. But I'll turn to Ms. Ganata.
No, I would definitely agree with that. I think that a lot of the conversation that we do have around CEQA and housing, and when we start talking about market rate development getting streamlined also, that's not going to ease the issues for environmental justice communities and low-income communities of color. We can't depend on thinking about a trickle-down economic theory to solving the housing crisis. I do think that there are different things we can do now to help a lot of communities. And I think to Aruna's point that there is not just CEQA is not the barrier to that part. There are things we can do proactively to talk about housing and affordable housing and those issues. I think we can think about how we rezone. I think that was mentioned earlier. And where are we rezoning? Again, I think it is talking to different city leaders and folks who are working in jurisdictions, also looking at your general plan, thinking about what does the city or the jurisdiction look like 10 years out? And those are all conversations that can happen, But it also, CEQA helps that process too, because you also have to talk about that. How does that happen within your community?
Right. I want to ask a question. So you've described CEQA as living document and a living law, and I would agree with that. But I guess my question to you is, with all of these exemptions, and we've heard testimony about, well, we'll exempt that, or, this is a priority, we'll exempt that. I'm going to try to be provocative, but what if I have a statute about murder? And I say, well, if you've killed your next door neighbor because you don't like them, that's okay. Or if you don't like the guy who wasn't nice to you in the grocery store, that's okay. So what I think our discussion here is there a way to not just exempt from the law, but to have a law which addresses what your concerns, what you're talking about, having these communities participate, having these issues come to the fore, having those discussions, but not turning around and saying, well, we're just not going to make CEQA work for this group, but it's going to work for this group. Are there tweaks to CEQA? And to Anthony's point, is there a middle ground of, not touching it versus touching it to achieve the goals that you both are articulating with great passion, but not just saying, well, the only way around that is to exempt somebody from the law. And I think that's what we're trying to get our head around. It may be that the answer is no. It may be the answer is yes. But that, I think, is really where we're sort of fishing right now.
So I agree that exemptions are a very imperfect solution to some of these problems. Well, I appreciate the analogy you're providing to murder. I think that CEQA, part of the challenge is CEQA deals with incredibly complex problems. It deals with our environment. Environment includes so many things. It deals with community health, public health, and it deals with how do we build and grow. These are huge questions. And CEQA also has to apply for the entire state, from Mendocino County to San Bernardino County to San Diego County to San Francisco. You have a law of huge applicability that's being asked to do a tremendous amount of things. Be the place for community groups, environmental justice groups to engage in how projects are built in their community. Have transportation projects be approved. Address all of these things. I don't think it's entirely surprising that there are occasional outliers, but I don't think we throw the baby out with the bathwater. We have to preserve the good that's in CEQA, and little tweaks around the sides and all of that may be very well intentioned, but they have unintended consequences that affect people's lives, that affect our environment, that sometimes we cannot undo. And so that's why I just proceed extremely cautiously when we talk about CEQA reforms, because I see the good that CEQA can do, but I also see what happens when we don't have it. You can look in other places. The affordable housing crisis is not unique to California. It is happening throughout the state. But when we build housing here, we know that there's certain protections in place. But I don't know if people saw recent coverage of a community in Arizona where they don't have water for their homes. And so they were trucking in water. Now that water isn't coming in. There's CEQA case law that says, hey, you need to show that there's water supply, and in order when you're building a house. So, I'm not saying CEQA is a perfect statute. It operates in an imperfect world that we all live in, and it's being asked to do a tremendous amount. And I think it has a track record of success. A lot of the sometimes the stories that get the headlines are not about CEQA success. A lot of CEQA success is not very sexy. It happens in the background. It's a community hearing that was attended by 15 people on a Tuesday evening. It is, a small, it could be an affordable housing project that's able to go through. There is a tremendous amount of good happening in CEQA. And I think when we talk about changing it, we don't want to lose that. And it's hard to come up with reforms that don't sacrifice that.
I also wanted to add, I think that when my organization uses CEQA. Oftentimes that is a way for community members to become organized and figure out what's happening just in their neighborhood. So I think that is such a huge aspect of just leadership development, and being able to be a civic leader in your community is tremendous, especially when you have so little resources that you can talk about what's happening there. So, I mean, when I think about CEQA, those are the things that I really am fighting for, because how else will those communities be able to do that?
Well, let me look to my commissioners. Do I have any? Yes, please, Commissioner Buiza.
Last, ready to comment. I'm gonna take that opportunity. I have this favorite saying that there's a crack in everything, and that's where the light comes in. And what I've heard so far from since this morning and this afternoon is there's a lot of cracks in CEQA, but what Jennifer had said, the professors this morning, the two of your things, there are small and big ways to fix it. And I'm hoping that, not so much a question, but a comment around some of the lessons that we've learned mutually in a moment where the stakes are so high because we're now having these combined challenges on our environment. We thought it was just wildfire and earthquakes, the problem of California, but now it's flooding and snow, right? So it's just like really encouraging, especially the advocates from the community who live the experiences of your stakeholders on the ground to make sure those sources of light come in. Because as I said, even from that moment of stakeholder engagement, there's so much data that could challenge an EIR, for example. Is language access part of that? Is access to healthcare, food, safer environment where not a lot of crime is taking place? So I just wanted to just add that to the mix because it's really been a very educational day for me. So thank you.
Yeah, and that's also why we're going to miss you, because you consistently bring to the front a perspective that not all of us have either experience with or are smart enough to know when to articulate. Thank you again. I'm not seeing any other questions or comments from commissioners. I do think that part of what might be an aspect of our report with respect to particularly zoning and land use, which seems to me foundational. It's one of the many aspects of the bouquet that we can look at with respect to CEQA. So maybe part of our report ought to be a list of every assembly representative and senator who's going to be termed out and who doesn't want to move on to higher office could be positioned to introduce legislation that would address specifically with those kinds of things. Right. Yeah. And then they could be appointed to the Little Hoover Commission. Let me just express our appreciation for what you've given us today. Like the other witnesses through the course of the day, you enrich our experience because you're out there pounding on the streets and meeting with people in the community, offering them actually hope and the possibility of their being able to be empowered to make a difference in their lives. And once you've done that, their life changes forever. I want to thank you again for your testimony.
Thank you, Mr. Chairman. So we will move on now to the public comment portion of the meeting. We will take public comment both in the room here, if there are people who wish to make public comment, and from those who are joining the hearing via Zoom. If you've joined the meeting via Zoom, please use the raised hand function to indicate that you wish to make public comment. Or if you have called into the meeting, you may email us at littlehoover@lhc.ca.gov, littlehoover@lhc.ca.gov, and give us your phone number so that we know who to unmute if you are called upon for public comment. In keeping with the Commission's traditional practice, public comment is limited to 3 minutes per speaker. Please limit yourself to 3 minutes. And the total public comment session today will be limited to 30 minutes. We also have additional hearings upcoming on CEQA. And so if we have a lot of people online who wish to make public comment and we can't get through them all in 30 minutes, We will hold additional hearings on CEQA on April 13th and the 27th. So with that, we'll begin with public comment from people who are in the room. I have one request in writing already, which is Jonathan Pruitt, I believe. Mr. Pruitt, you have 3 minutes. Believe that should be on. There you go.
Can you hear me now?
Thank
Great.
you.
Good afternoon, commissioners. My name is Jonathan Pruitt. I am with the California Environmental Justice Alliance. CEHA is a statewide community-led alliance that works to achieve environmental, climate, and social justice by advancing policy solutions. For CEHA's grassroots community members, the California Environmental Quality Act is an important tool for safeguarding our community's health and well-being because it promotes procedural and distributes justice for overburdened and under-resourced communities. CEHA would like to uplift the following points about the critical importance of this environmental law. One, CEHA plays a vital role in protecting the basic civil rights of EJ communities when it comes to assessing clean air, water, and soil, free from pollution and toxic contamination. Contrary to many people's beliefs, developers do sometimes build on toxic lands and next to noxious land uses. And a strong CEQA can provide mitigation solutions that protect impacted EJ communities from developments that produce severe health harms, from refineries to warehouses to housing that is unknowingly built on toxic lands or contaminated land. CEQA also protects community members' basic civil rights to be included in the land use decisions that impact their lives. The participation of the community members in local land use planning is essential, as it can provide invaluable firsthand data that the local governments may overlook. Unfortunately, local governments' processes can be discriminatory and oftentimes do not create many meaningful opportunities for politically marginalized communities to really have a voice. For the overwhelming majority of the time, development projects prioritize financial interests and corporate profits over the local community health. CEQA has been unfairly blamed for the state's housing crisis, exempting developments from environmental review and limiting judicial remedies are popular false solutions to the housing crisis. These policies not only undermine the ability of the low-income communities to protect themselves, it also doesn't lead to big increases in housing development, let alone the affordable housing that we need. And high construction costs, the speculative market, and the developer profit maximization and local planning restrictions are those barriers, are those real barriers to housing. Furthermore, CEQA has already been modified or streamlined many times over the years to fast-track housing. And so CEHA urges decision makers to prioritize protections and enforcement of CEQA as a critical tool for promoting environmental justice and safeguarding the health and well-being of our communities and all Californians. It's crucial that CEQA's protections are not watered down or not weakened. We also recommend that the policymakers consult with CEHA's Environmental and Housing Justice Platform for key policies and recommendations on creating safe, healthy, and affordable housing in California. Thank you so much.
Thank you very much, Mr. Pruitt. If there's anyone else in the room who wishes to make public comment, you can come up to the podium now, even if you've not filled out one of the forms. Anyone else wishing to make public comment in the room? If not, Ashley, do we have people who've indicated they wish to make public comment online?
Yes, we have a line of folks online.
Okay, go ahead, please.
First, we're going to start with George Haig. George, I'm now turning on the ability to unmute yourself.
Mr. Haig, go ahead.
CEQA is the best tool to achieve environmental justice. I'm a retired teacher who lives in Moreno Valley, where the planning staff and the majority of the decision makers have never seen a warehouse they do not like. As a teacher, I've seen the impacts of these decisions. CEQA requires agencies to disclose the environmental impacts of a neighborhood project and allow the public to comment. In Moreno Valley's disadvantaged and low-income communities, which bear the brunt of air pollution, CEQA presents the only opportunity for these neighbors to learn about a polluting warehouse coming to their backyards. My city has approved and is in the process of approving massive warehouses with hundreds of daily diesel truck trips within 10 feet of family homes, 17 feet of family homes, 20 feet of family homes, across narrow roads from these homes, and even a charter school. This law allows communities to hold these elected officials accountable and push them to consider measures to mitigate environmental harms. In the Inland Empire, CEQA allowed communities to push back against industrial developers requiring electric trucks, charging stations, solar panels, and very important, building setbacks for warehouse projects. South Coast Air Quality Management District recently wrote 2 letters on the latest Moreno Valley warehouse approval, only 17 feet from homes. But since the project's mitigated negative deck was pushed through in less than 30 days, very important AQMD recommendations were not incorporated. CEQA protects existing family homes from being unhealthy places to live and raise families. If we make more projects exempt from CEQA, we take away the best environmental justice tools for frontline communities. Watering down CEQA will silence EJ communities. I'd also like to take a moment to mention biodiversity and how important it is in California. I'm also fortunate to live near the San Jacinto Wildlife Area with threatened and endangered plants and animals. It's through CEQA that we are protecting this from becoming an urban island, totally surrounded by urbanization. It needs to be protected. The linkages between this area and surrounding important habitat needs to be maintained. It's quite possible that a single small project could break up this very important linkage to allow animals to pass to one important habitat to another. We must make sure that CEQA remains in place so that we can maintain these linkages and maintain our biodiversity in a very, very special state that is blessed with so many. I thank you very much.
Thank you, George. Next, we're moving on to Christopher Wilmers. Christopher, you now have the ability to unmute yourself.
Yeah, thank you very much. My name is Chris Wilmers. I'm a professor of wildlife ecology and director of the Santa Cruz Puma Project. And I study how land use change impacts wildlife populations throughout the state. I have 3 points I wanted to make about CEQA. The first is that uncontrolled sprawl has cut into sensitive habitat. CEQA requires cities and counties to analyze and mitigate the impacts of major development projects that have a potential to harm sensitive habitats and wildlife corridors. This is very important because for decades, unchecked sprawl has paved over and fragmented crucial habitats for many California species, including mountain lions. If we want to combat the climate and extinction crisis, we need a strong CEQA that compels our elected officials to look before they leap and approve a harmful project with lasting consequences. The second point is that California can address both its housing and climate crises. We must combat the housing crisis alongside the fight against the climate crisis. CEQA is the best tool to achieve the state's 30 by 30 and climate goals, while also offering exemptions to many housing projects to simultaneously fight the housing crisis. There are exemptions in place to streamline the CEQA process for infill housing, multifamily housing, supportive housing, homeless shelters, and other projects that address the housing shortage. Meanwhile, CEQA requires a careful consideration of greenhouse gas emission, sensitive habitat destruction, water impacts, and cumulative climate impacts to adapt to a warming climate. The third point I'd like to make is that weakening CEQA would risk the strong environmental protections that have served California well for more than 5 decades. There are proposed bills aiming to further streamline, weaken, and reform CEQA. This would put California's environmental protections at great risk while doing nothing to build more housing. That's because addressing the housing crisis means focusing on the real impediments to construction, which are high housing costs, inflation, restrictive zoning, and agencies and municipalities that resist housing developments. The instances in which CEQA is used to delay a quality housing project represent a small minority. There is no law that can stop a certain group of individuals from opposing a project. For every case that draws big headlines, there are many more instances in which warehouses, development in wildfire zones, and industrial polluting projects are approved even with CEQA. The vast majority of CEQA cases are not frivolous. Oftentimes, CEQA works behind the scenes, improving projects before they go to litigation. Thank you very much.
Thank you, Chris. Next, we're moving on to Marvin Norman. Marvin, you now have the ability to unmute yourself.
Mr. Norman, go ahead, please. Mr. Norman? Ashley, why don't you go on to the next person in line?
Next, we're moving on to Theo Corretto. Theo, you now have the ability to unmute yourself.
Hi, my name is Theo Corretto. I'm a legal fellow with Communities for a Better Environment, based in Wilmington and southeast counties of Los Angeles, or southeast cities of Los Angeles County. I'm speaking to support a strong CEQA. As you've heard from a number of folks already, CEQA is an essential law to upholding environmental justice in California, and more often than not does not lead to litigation, but leads to environmental protections on projects, both affordable housing and other much more polluting projects in disadvantaged communities. Organizations like CBE rely heavily on CEQA to protect our communities that are often the most pollution burdened communities in California from developments like multifamily housing on contaminated land, industrial projects that will increase the pollution burden in our communities, and other similar projects. Weakening CEQA is not the solution to solving the housing crisis in California. And I would urge this panel to deeply value the testimony of the two most recent panelists that you had in front of you in considering CEQA's future. Thank you.
Thank you, Theo. Next, we're moving on to Dan Silver. Dan, you now have the ability to unmute yourself.
Good afternoon, Commission members. I'm Dan Silver, Endangered Habitats League. Founded in 1991, we work on ecosystem protection and sustainable land use planning in 5 Southern California counties, stressing collaborative conflict resolution. We have extensive experience with CEQA. CEQA provides meaningful public participation and forces serious consideration of tough issues that would otherwise get swept under the rug, such as building in high fire risk or flood zones. Without CEQA, alternatives would not be examined, and there would be no accountability for the adequacy of mitigation. Having the public at the table via CEQA is essential for the environment and essential for public safety. The overall solution to more housing and environmental protection is better planning. CEQA supports better planning. It can't do all the job by itself, though, and it should not be blamed for the failures of bad planning. Thank you.
Thank you, Dan. Next, we're moving on to Gracia Orozco. Gracia, you now have the ability to unmute yourself.
Good afternoon, Commissioners. My name is Gracia Orozco. On behalf of the Center on Race, Poverty, and the Environment, an environmental justice organization serving communities in the San Joaquin Valley, we're here to advocate for CEQA and our work in the San Joaquin Valley, where we have extreme non-attainment of national ambient air quality standards and the state ambient air quality standards. Every day, we see more and more projects proposed in our communities that risk the lives of the residents living there. Without CEQA, our residents and community members would have no way to know about the harms that come with these projects, or let alone try to combat them. In the cumulative, having one warehouse in an empty lot doesn't sound too bad. When you have multiple warehouses, multiple oil and gas permits being submitted, and multiple unproven methods of sustaining carbons and hydrogen facilities in our area, it becomes concerning that our low-income communities are becoming dumping grounds for the industry. CEQA is one of the only lines of defense that we have to fight any of this. Without the protections that the state does not provide us, there would be no way to know, no way to provide input, and no way to even try to fight back. Currently, the oil and gas industry is petitioning to eliminate a law that passed that would even provide setbacks for oil and gas permits, and that is being combated. CEQA is, again, one of the lines of defense that we do have, and we have used it to successfully stop the county, in Kern County specifically, from issuing more oil and gas permits for lack of consideration of the public health there. Now more than ever, we need CEQA to maintain our community, to make sure it's safe, and dismantling it or weakening it is not a solution to the housing crisis. In fact, streamlining housing with exemptions to CEQA would only lead to leading low-income community members into unsafe and toxic land, which is something that we want to avoid. We want to make sure that everyone has access to clean land, clean water, clean housing that is safe. And as such, we recommend that we commit to protecting our communities by upholding and strengthening CEQA, making sure that it's more of a transparent process, making sure that notices are in multiple languages to increase that accessibility, adding convenient forums to aid in the public input process. All of these would be very helpful to avoid and protect hazardous land uses in the neighborhoods that are already impacted by big industry. Thank you.
Thank you. Next, we're moving on to Alex Castellano. Alec, you now have the ability to talk.
Hello, thank you. This is Alec Castellano from the Environmental Justice Program at Catholic Charities of the Diocese of Stockton. And we believe that any kind of policy that undermines CEQA is definitely inappropriate, considering that we want to make sure that the community has access to homes that aren't around hazardous sites and other pollution factors. That's all. Thank you.
Thank you. Next, we're moving on to Marvin Norman again. Marvin, you now have the ability to unmute yourself.
Hi, yes, can you hear me now?
Yes.
Okay, good. Yes, hi, my name is Marvin Norman. I'm the policy coordinator with the Center for Community Action Environmental Justice out of the Inland Empire region. And we're calling because we have found CEQA to be a useful tool for us. We, as several little projects we've faced in our region have actually been mentioned today, such as the World Logistics Center. We have been working with community members to keep those types of uses away from our schools, our homes, and indeed not just away from our homes, but replacing our homes. Someone else earlier this morning mentioned another project that we are currently watching still that will displace over 700 homes, and it's still going through the CEQA process, the administrative process, but we are watching it to see what can be done to keep that from happening, from displacing people to put up warehouses. But while we've been able to use CEQA, we have realized that CEQA has limits, and actually some of the exemptions that have been passed in recent years, actually we've seen them actually get used by warehouses. We've seen a couple warehouses use the small infill exemption to place themselves right next to schools, and we have had limited recourse in that situation because it was a small lot and it met the zoning, and so there was no CEQA remedy. And so on top of that, there are many as the Inland Empire continues to grow. A lot of the growth has happened at Sprawl, which even though the large projects do CEQA, that they are still generally ultimately approved. So we would like to see CEQA. It is useful, but it certainly has its limits, and I don't have the answers, and I don't think any of us have all the complete answers. But it sounds like we are seeing some perverse incentives in our case, quite honestly, where projects that should be, the projects that are being approved are generally through the CEQA process generally are the less, well, the CEQA process isn't able to stop the most egregious projects that we are seeing. But we are not seeing it used at the same level to stop other housing projects that maybe is being happening in other parts of the state. Thank you.
Thank you, Marvin. And that's all we have for public comment requests online and via email.
Thank you, Mr. Chairman. We've completed the agenda.
Thank you. Thank you to all the commissioners for participating today. We haven't traveled much in the last 3 years. I think this is probably only our second public meeting. We met in Riverside in public and this month, and it was a real pleasure to spend time with all of you in one place all at one time. And thank you to all of the witnesses and the members of the public for participating, and that concludes our meeting.
Well, Ethan, if
Oh.
I could just very briefly, can you tell when the next CEQA hearing will be, just so people who are following this will know what we're doing?
Yes, we will. The next secret hearing will be on April the 13th, and then there will be one more at least on April the 27th. Those will be held via Zoom. And if members of the public wish to know about those hearings, best thing to do is to go to our website, lhc.ca.gov, lhc.ca.gov, sign up for our email list, and you will receive full notice of all commission activities. April the 13th at noon.
Thank you.